Hello, everyone, and welcome back to day 2 of the Provincial HSJCC Specialized Courts Forum. We hope that you've enjoyed yesterday's session and are excited to dive into today's discussions. To those who are joining us for the first time today, welcome. Just as a reminder, the HSJCC Secretariat are your official hosts of the forum. If you have any questions or require any technical assistance, please message them directly using the chat box and they will do their very best to assist you. As a general attendee, your cameras and microphones are automatically turned off. You will only be able to interact with the speakers using the general chat box and Q&A box. If you wish to enter a comment into the general chat box, please note that all attendees will be able to view it. If you have a specific question for one of the panelists, please enter it into the Q&A box, which you will see on the bottom panel of your screen. Please note that there will be dedicated time for question and answers at the end of each presentation. We will do our very best to get to you as many questions as possible. I will now turn it over to Little Brown Bear to provide an opening prayer for our day 2 of the forum.
Miigwech. Bojo ani nana bojo sego skanagoa tuanchi yatehea kona he destiny ungwa ridaa makwado dem. I'm a Little Brown Bear and I'm from the Bear Clan. And this morning I took all of the words that were said yesterday and did a sunrise ceremony and for prayers of presented tobacco to the Creator and smoked my ceremonial pipe, and these words came to me, and I just wanted to welcome everyone this afternoon as we come together this afternoon with our hearts full of love and concern for our cities, our communities, our members, the neighborhoods we live in, the streets, the highways, the waters, the lands on which we work, and the woods where we like to explore and renew our spirits. We look to you, Great Spirit, to help us heal our relationships and to inspire us, guide us, so that we may see the way forward clearly as we seek to bring about right relations between all of the nations. Help us to turn others away from the unhealthy and destructive pathways and dialogues. Forgive our missed opportunities for those we have been impatient with when we have not listened with openness to others and their points of view. And for our limitations of tiredness, our feelings of discouragement, and our lack of courage. We ask you, Creator, or God, or who you pray to pour out your Spirit upon us today, upon your neighbors and upon the leaders, upon those who have come to this place today with open hearts and minds and the eagerness to learn and to help. We express our humble gratitude to you for sending so many gifted people to help and that work among us. We respect their efforts in all that they do and encourage them. We are so blessed to be able to provide constructive feedback when needed, but in ways that build people up, not tear them down, and to advocate for those support they need to carry out their work effectively. Creator, God, we pray that you will guide the work of all those who have been called to help and to help us find answers to the challenges we face so that our community and their members may begin their healing journeys. We open to the winds of constant change, the warmth of a new day for our communities and their members. We remain so ever humble to have your healing medicines as we cleanse with the smoke of the medicines that are sacred to many of our people. The cedar, the sage, the sweetgrass, the lavender, and the tobacco for communication. Inspires us and sustains us so that we may strive everything that is true and everything that is honorable and everything that is pure. So I ask Grandfather Sky and Grandmother Moon and our oldest brother, the Sun, Mother Earth, the ancestors, the directions, the spirit animals to walk beside us today in a good way and to carry us through what we need to share for today. I say Chimigwich, Nyawagoa, Marci, Tenege. Thank you. Aho.
Get myself off mute first. Well, Ellen, thank you for that wonderful opening, Little Brown Bear. I'm now delighted to introduce our first guest speaker of the day, the Honorable Lise Maisonneuve, Chief Justice of Ontario's Court of Justice. Ms. Maisonneuve was appointed Chief Justice of the Ontario Court of Justice on May 4th, 2015. She was appointed to the Ontario Court of Justice in 2003 and presided over criminal matters in the Ottawa area for 12 years, rising to the role of Regional Senior Judge East Region in 2011. In 2013, she became the Associate Chief Judge of the Ontario Court of Justice, where she distinguished herself as a leader and an innovator, responsible for court initiatives related to court modernization, judicial education, public legal education, and addressing criminal court delay, among many others. Please join me in welcoming Chief Justice Maisonneuve.
Thank you very much, Katie, for that very warm introduction. It's a great pleasure for me to address all of you this afternoon, and an honor for me to set the stage for my dear colleague and friend, Chief Justice Pam Williams of the Provincial and Family Court of Nova Scotia. First, let me commend you on the collaborative nature of this forum, bringing together so many people, assistant crown attorneys, defense lawyers, duty counsel, mental health court workers, case management workers, and many others, including, and perhaps most significant, those with lived experience with these courts. How fitting and appropriate is it to bring together and listen to so many varied voices, given the philosophical underpinnings of specialized courts, as they are based on the principles of interactions, bringing together judges, parties, experts from the communities, and others to discuss and find solutions for vulnerable individuals while protecting those who may be potential victims. And how fitting to be having these discussions today in Ontario, the province which introduced specialized courts in Canada. In 1998, the first two problem-solving courts opened in Toronto. One was a mental health court, established in May of that year. The other was a drug treatment court, established in December 1998. And at the time, these courts represented a significant and important departure in the handling of criminal charges for certain segments of the population and for certain types of cases. Yesterday, I understand you had the privilege of hearing from one of the co-founders of the Toronto First Drug Treatment Court, Justice Kofi Barnes, who served as a federal prosecutor in that court. As you can tell from the three Ontario Court of Justice judges who also spoke yesterday, being Justices Cameron, Donald, and Perkins McVeigh, specialized courts continue to fill an integral part and an integral role in our court and our service to the public. And as we can see from this gathering, those first courts laid the groundwork for what has grown into this impressive forum, where you continue to discuss the best practices in therapeutic courts in Ontario. I know that the pandemic has affected therapeutic courts dramatically, especially in Ontario, given the vulnerable populations we serve. And that makes this gathering all the more timely and important, given the challenges that we are all facing at this time. I am very pleased that I will be followed this afternoon by Chief Justice Pamela Williams. Now, I know she will be receiving a fulsome introduction from Sarah Diaz, but I do want to mention how much I admire her leadership, dedication, and innovation in promoting specialized courts in Nova Scotia. And I also admire the effect that her leadership has had on other courts across Canada. I can tell you that we, Chief Justice, rely on her. She gives us great advice, especially when it comes to specialized courts. And I want to thank Pam for all of her dedication. I know that after you hear her speak, you will learn much from her this afternoon and you will benefit from her wise words. I want to wish you all a very productive day of sharing and learning. And thank you for allowing me to address you this afternoon. Thank you very much.
Thank you, Chief Justice Maisonneuve, for taking the time to be here today and share your thoughtful remarks. And with that, I would now like to introduce our next keynote speaker and special guest, the Honorable Chief Judge Pamela Williams of the Provincial and Family Courts of Nova Scotia. As you will recall, Chief Judge Williams participated in our first panel discussion yesterday, where we heard from our judges on best practices for specialized courts. Chief Judge Williams was appointed a judge of the Provincial and Family Courts of Nova Scotia in September of 2003. She has presided over adult and youth criminal proceedings and occasional family court matters. Between October 2006 and August 2010, she was the primary youth court judge in the Metro Youth Justice Court. Since then, she has been the dedicated judge for the Dartmouth Wellness Court. She also presides in adult criminal court. In 2011, she was appointed Associate Chief Judge of the Provincial and Family Court. Nearly 2 years later, she was appointed Chief Judge of the Provincial and Family Court for the province of Nova Scotia. Chief Justice Williams, we are delighted to have you back with us today to speak about Nova Scotia's experiences within your wellness courts, as well as learn more about your plans for sustainability and expansion of these courts.
Well, thank you for that introduction. Thank you, Lise, for those kind remarks. And thank you for Little Brown Bear's introductory prayer, which was very inspiring. I am going to speak with some notes in front of me on my monitor. I think that's the best way that the camera can continue to capture me without looking down. So I've been asked to speak on some promising practices and evaluation for our courts here in Nova Scotia. By way of background, I can tell you that in 2009, the Nova Scotia Mental Health Court, which is now the Dartmouth Wellness Court, was a government initiative and came about as a result of a high-profile case in our metro area where we have half the province's population. There was an offender who has severe mental health issues, and she was appearing before the same judge time and time again on relatively minor matters. And one day he decided to direct the sheriffs to deliver her to the Minister of Health's office. And that was the impetus, I think, for folks starting to get their heads around the idea of a funded court for Nova Scotia. And it's not surprising perhaps that what we did was we went around to a couple of different or 3 or 4 different courts to have a look at how it's done elsewhere. And notably, we went to Toronto, we went to London, Ontario, and it was the occasion that we went to Ottawa that I first met Chief Justice Maisonneuve. And so we looked at best practices from around Ontario, brought back to Nova Scotia some of the ideas, put together a steering committee, and developed a framework for eligibility for our program. We decided early on that we were going to be a service connector as opposed to a service provider. We simply didn't have the funds or the resources to have in-house services. So the idea was to have clinicians on our team who could then connect folks with community supports, and we would then monitor and support those people while they were in the program. So we do, like others, have a dedicated team, a dedicated judge, Crown, defense lawyer. We started with 2 clinicians. One was a forensic nurse, the other a social worker, and we had a probation officer. In addition, we got some in-kind resources from the Nova Scotia Department of Mental Health and Addictions, in a forensic psychologist and consulting forensic psychiatrists if we required an NCR assessment. Early on, we wrestled control of the program away from the bureaucrats. And we were very much proponents of the team leading the way and having monthly stakeholder committee meetings to help develop policy and make changes as best we could. We took a flexible approach. We wanted to modify, develop and modify best practices because we knew we weren't going to get it right from the get-go, and that there were going to be some changes needed. Although we did see the need for some foundational guiding principles. So my first takeaway for anyone who's looking at establishing a wellness court is to build a framework. But as I said yesterday, don't box yourself in. You will need to evaluate, adjust, and readjust and respond as things change. And I would say over the course of the last 11 years, we've gone through quite a metamorphosis. Early on, we were devoted to being a service connector as opposed to a service provider. However, there were times when services in the community were not readily available, and our clinicians had to fill those gaps by actually providing services. What we did realize from the very beginning, though, was the importance of networking, developing relationships with the community, and learning and understanding from that, and then from there, planning and action. So we had collaboration, close collaboration with government entities, with community, and of course with First Voice. What was to be a monthly management committee to get us up and running for a short duration has now turned into an 11-year process. And we continue to have monthly meetings. We continue to invite in community partners who do presentations, and we continue to discuss issues that affect our programs. One of our early aha moments was when we realized that up to 80% of the clients we were seeing in the mental health court also had concurrent substance abuse issues. And we looked around and we said, we need an addictions worker. We don't have that expertise at the table. And so the timing was somewhat good. We had, the thinking was coming along that it was time to start bringing together mental health and addictions and not treating these two areas as mutually exclusive. And so with the help of some leadership at Mental Health and Addictions, we were able to convince them to provide in-kind support in an addiction worker for the mental health court. We started doing random testing. The testing was being done, first of all, by our probation officer until probation services said, no, that's a liability issue. We then went to a private service provider, which was incredibly expensive. And then we settled on hiring a retired LPN on a part-time basis to come in and do our urine testing, which she continues to do. In the beginning, we did drug testing with our urine dips, and we had a breathalyzer machine. As a result of COVID, we haven't been able to use our breathalyzer, so we've gone now to urine strips, which test for both drugs and alcohol. And that's been a benefit because the breathalyzers only work for about a 3-hour span, whereas the urine dips can last upwards to 48 hours or more. We also decided that we wanted our court to take a restorative approach. We wanted to hold people accountable. We wanted to be able to address and repair harms and restore relationships where possible. And so we really were keen on establishing some restorative sessions in circles, whether they be healing circles or circles of support. The other thing we wanted to do was to have a place for victims. And because our court didn't always and usually did not require a guilty plea, the victim impact statement wasn't triggered from the criminal code. And so we developed what we call a victim voice statement. And that required establishing a relationship with victim services, having them part of our monthly committee meetings, and engaging victims in a way that allowed them to have a voice in the process, whatever that voice might look like. They might just want reports back on what's happening in court. Our Crown Attorney has devoted a good deal of time in connecting with all victims to get a sense of what, if any, participation they want to have in the process. And it's been really quite something. We also knew that we needed to have processes and protocols in order to keep us accountable. So there had to be due process. There had to be sound, equitable, and transparent decision-making. And we had to, as we went along, realized that the integrity of the program depended upon us being able to ensure that we could manage the risks of those who come into the program. Because again, early on, we made a decision that we weren't going to be a court just handling property damage and shoplifting. And so if we were going to be dealing with offenders who had committed very serious offenses, we had to make really sure that we could manage their risk in the community. Sometimes this involves our forensic psychologist who'll do a risk assessment for us. Other times, our clinicians are able to do more rudimentary risk assessments, either through various techniques that we have. So a needs assessment is done after a screening assessment determines they qualify for the program. We do assess their level of risk, their level of need, and that will determine the level of response that we provide to them. For the most part, people remain in our program anywhere from 12 months onward, depending on the circumstances. A support plan is developed, which will highlight a person's strengths and areas where they need support and guidance, and that will help us track their progress. So every time they appear before the court, there's a tracking sheet with a series of questions, which help us to determine whether they are meeting expectations, whether they are below expectations, or whether they're exceeding expectations. If they're below expectations, there may be some sanctions imposed, similar to the types we discussed yesterday. So as I indicate, or perhaps I didn't, our program was about 75% funded. But there were areas that we wanted to expand upon. For example, Halifax is a city that has a lot of veterans. And so we were starting to see a lot of veterans before our criminal courts charged with offenses. So we began dialogue with Veterans Affairs. They were very keen on partnering with a program in the country because they had determined, unlike the US, where the population of victims were sufficient enough, or veterans, I'm sorry, were sufficient enough to support a standalone veterans court. That wasn't the case in Canada. And so they looked at a number of courts and settled on ours to partnership with. And so we've had a very rich partnership and have come to understand PTSD as it relates to veterans and first responders in a way we never could have had we not had developed that relationship. We had one participant in our program in particular. You know, he told me one day, he said, I was shot in Afghanistan, I was stabbed in Somalia, and I was blown up in Bosnia. And apparently his position in the military was so top secret that he wasn't even able to really discuss it with us. He did have a large badge, honor badges from where he had served in a number of places. He suffered from PTSD and had, as a result of his illness, threatened some folks and found his way charged and into our program. He eventually got a service dog, a big dog, I forget what kind he is, but he came to the court every week that David did, and we enjoyed seeing, Norm was his name, seeing both David and Norm on a weekly basis. We saw the need for a drug court as well. Our counterpart in Kentville got a little bit of federal funding to establish a drug court. And we said to ourselves, you know what, we've got the framework here to be able to develop some sort of court, but we had no funding. So again, we went to the health authority and partnered with the opioid treatment program to establish an opioid court. We have as well partnered with some residential treatment facilities to provide an opportunity to some hard core alcoholics who find themselves in trouble with the law. So as a result of that metamorphosis, we shifted from being simply a mental health court to becoming a wellness court with 3 umbrella programs underneath it. One of the other things that we did was originally there was funding in our budget for transitional housing. And when I say transitional housing, it was simply money per month that we could use to pay for an apartment. The difficulty was that we couldn't always have that apartment occupied. And so months would go by, we'd be paying for this service and not using it. So as time went on and our clientele grew, we saw the need for a 3rd clinician. And so we made the decision to discontinue the housing, transitional housing, in favor of a 3rd clinician. So now we have a social worker, we have a forensic nurse, and we have an occupational therapist. One of our other aha moments came one day when I was sort of thinking about the rates of remand for folks marginalized, that being our Indigenous and African Nova Scotian populations, and how they're overrepresented in the criminal justice system and in our jails. But I looked at our participants in the program and said, you know what, our program doesn't really reflect that. So why is that? We started asking ourselves. And what we discovered was often these folks didn't meet our eligibility criteria because they did not have a major mental health disorder diagnoses. And I emphasize the word diagnoses. They had the disorders, but they weren't diagnosed either because they'd never been seen in the mental health care system, or they had never been fully diagnosed with a particular disorder. And so we started making some alliances and connections with the Indigenous community and the African Nova Scotian community. And we've come to the point now where we better understand that there are a lot of people affected by cultural trauma as a result of systemic racism and discrimination that has not always been recognized as a major mental health disorder. And so with the help of the African Nova Scotian social workers, we have now developed a process for getting not only those IRCA assessments, those impact of culture and racial assessments done in the criminal context, but we have clinicians now who will do cultural trauma letters for us to help assist our clinicians in being able to arrive at a diagnosis and then satisfy the eligibility criteria for our court. So we have done a lot of work on being trauma informed and seeing folks' strength, acknowledging the trauma, demonstrating an openness, providing choice to people, modeling the trustworthiness and the honesty that's needed, and building that collaboration. In keeping with that has been our, just looking at my time, our human-centered approach, really focusing on supporting and monitoring a person's recovery, looking at the types of supports they need in order to become a whole person. Often we know that folks who struggle with mental health and addictions are impoverished, are often homeless, who do not have sufficient social supports. And so we try to identify what those needs are and to be able to identify and celebrate their strengths. And I mentioned yesterday briefly about our wall of hope, where people in the program are encouraged, if they'd like, to present a piece of art that they've done that can go on our wall. We've had people that have created pieces of poetry and have read them. We've had people who have given testimonies. I can recall one gentleman from Cape Breton. One day we were just having a discussion, he and he told me that he liked to do some buskering. And I said, well, what do you do? He says, well, I play the harmonica. I said, wow, isn't that great? Do you think someday you might want to come and play for us? So he was wearing a backpack. He says, I got it in my backpack right now. You want to hear it? And I'm like, okay, let's hear it. So he gets it out, he plays a little tune, and everyone in the courtroom is clapping, and just kind of spontaneous things that celebrate a person's gifts and talents. And so we're big on that. The other piece, of course, that I guess is a lesson learned is evaluation. So what I would say is it is best from the get-go to build some component for evaluation into your program. We did not do that. We kind of understood the need to collect some statistics in order to help, if the day should come, to justify our existence and to make our program sustainable. But we kind of got into the game a little bit too late. Having said that, we did have identified performance indicators, both from justice and from a health perspective. We engaged our data folks at the Department of Justice and at the Nova Scotia Health Authority, but it's been quite a journey. And we haven't got there yet because of data linkage issues, because of privacy considerations, but it's something that we are continuing to work on. And anyone who knows me knows that I speak of the 3 Ps: patience, perseverance, and persistence. And I'm confident that as we move along, we will soon one day be able to gather that type of rich data. In the meantime, we have had the benefit from 3 reports in particular. At the 5-year mark, we thought it important to create a mental health court report. We didn't have the funds to engage a professional to do this or do an evaluation. So the team cobbled it together. Everybody took a part, and my role was to edit the darn thing and make it sound as though one person read it. So it's certainly not perfect, but it was a snapshot of the data that we were collecting at the time, such as referral rates and eligibility criteria, age range by gender, offense types, program completion rates, the primary diagnosis that the person came into the court with, and the types of substances they may have been using. The Department of Justice did fund a 5-year evaluation, which was a prospective evaluation on examining short-term outcomes of the program. It was Dr. Marianne Campbell from the Center for Criminal Justice Statistics in UNB who took this on. It was somewhat limited in that she looked at a number of folks prior to their entry into the program in terms of their offending behaviors and their use of the medical system, and then looked at them 12 months afterwards. So in total, she only looked at 44 cases. So as I said, it was limited by duration so that she was unable to speak definitively on the rates of recidivism. Although what she did say was that rates of recidivism were somewhat reduced and that it took longer for people to reoffend if they did reoffend, and that they often reoffended in a less serious manner. So she looked at the degree of change in their mental health, as I indicate, their mental health recovery and their criminal risk and recidivism. And she came up with a number of recommendations which were really quite helpful. The first one being to tell the province, continue investing in this court, which they've done. She did tell us that we needed to target criminogenic needs to maximize risk reduction. So we've undertaken moral and emotional reasoning paths to try and assist with some of those criminogenic thinking patterns. She was the one that suggested integrating the risk-need responsivity model, providing low intervention to folks with low risk and low needs, and intensive interventions for folks with high risk and high needs. So we were able to develop a criminal risk screening assessment process with her assistance. She also told us that we needed to address in a more fulsome manner other criminogenic needs, including education, employment, pro-criminal peer associations, and leisure and recreation. And so we have done that, but we have certainly been able to do that much more successfully by having our third clinician who's an occupational therapist. And so that was when we were looking at hiring a third clinician, we were really hoping to get someone with that type of a background. So we've been able to develop protocols that more effectively supervise and meet the needs of high-risk offenders. And we've been able to identify the need to determine when somebody is ready for the program or not. So we have a legal aid lawyer who often says, we're in the business of providing opportunity, and it's up to the clients of what they do with it. But some folks, even though they say that they want to participate, they're just not at a place in their life where they're ready to commit to the type of hard work that's needed. And so we need to do readiness assessments for folks with severe addictions, and also for those who have borderline personality disorders, because they have to be committed to intensive treatment if they're going to continue with us. Finally, Dr. Campbell's final recommendation was to continue our in-house data tracking for further evaluations. And so for our 10-year anniversary, we engaged the Dow School of Occupational Therapy and several profs, secured some research grants, and developed a collaborative research team. And in honor of our 10-year milestone, we completed an evaluation, at least the first phase of an evaluation, which was qualitative in nature. The second will be quantitative and hopefully will enable us to do that data linkage that we needed. But the two questions that are driving the study are, number one, what are the health, social, and justice outcomes for people who've been referred to and or participated in our wellness court program since 2009? And secondly, what are the underlying ideologies, approaches, processes, and mechanisms of a wellness court program, and how these might impact program design and opportunity for a person's recovery? So the takeaway there is it is absolutely crucial that we build in data collection, analysis, and evaluation into any program that you have. We do have several other programs across the province. I'll skip over that to go now to very briefly. We saw the need to expand wellness courts. We have some ad hoc wellness courts across the province, and saw the need to develop a framework for some consistent practices and best practices if we were going to truly engage the health authority and other government agencies. We established in 2015-16 a working group of about 42 people, and then a provincial steering committee later for about 30 people. And so what we're doing now is we've identified underlying principles, developed a framework. We have a cultural awareness guide. We have non-negotiables, and we want to be able to support an evaluation framework. And right now we're in the early stages of strategic planning, have developed a subgroup to attack 4 pillars: communication, collaboration, consultation, 1, strategic partnerships, sustainability, and program enhancement. And we're at the point now where we are planning to present to key decision makers in government to enhance these programs. So to the final 2 takeaways: consultation, collaboration, and multidisciplinary approach is key. And secondly, sustainability and expansion require strategic, collaborative, and coordinated planning. So I think I'm just at the mark where I'm due to finish my presentation. So thank you so much.
Thank
Thank
you,
you.
Chief.
Go ahead. Sorry.
Thank you, Chief Judge Williams, for sharing your experiences, best practices, and lessons learned from Nova Scotia's provincial courts. There are certainly many opportunities and considerations here for specialized courts in Ontario. We are now going to begin our first panel discussion on emerging issues in specialized courts.
Katie, sorry, can I just interrupt? I think we have time for questions.
Oh, do we? I'm sorry.
Yeah. So I think Christine was just going to read through some that came in. Sorry to interrupt.
Okay, no worries.
Thanks, Katie. And yeah, sorry, that can be the problem with the virtual conferencing. But Chief Justice, thank you for that. A number of questions came in. The first one is asking, how many times per month do you access the psychiatric nurses services for evaluation for those clients?
So we have 3 clinicians that are actually on our team. So our psychiatric nurse does assessments, as does our social worker, as does our OT. So when someone's referred to the court, one of our 3 clinicians is assigned that person. They access health records after consents are signed. They meet with the person and they prepare the screening assessment report that comes back to the team, who then decides on a collaborative consensus basis whether the person is eligible for the program.
Thank you. That's great. Someone else is asking to know a bit more about the impact cultural trauma assessment that you spoke about. And is there any research or a website that you could share?
We do have a cultural assessment or cultural impact guide that I can share with you that's been developed. It's an emerging area, certainly. I mean, there's a lot of information out there on cultural trauma. 2 of the people that we access primarily are Robert Wright, who's a social worker, and Lana McLean. And they've done a number of impact of culture and race assessments here in Nova Scotia. And actually Robert has done, he did the one for Jackson in Ontario, and he's done others. You know, those are very rich documents akin to a GLADU report, which provides the background and context of the types of systemic things that have impacted their lives and have perhaps impacted their decision making in ways that impair their judgment and cause them to come into contact with the criminal justice system.
Perfect, thank you. Another question, wondering if you could elaborate on the sort of circumstances in which the court would deal with offenses involving alcohol as opposed to drugs. They reference, you mentioned those hardcore alcoholics. What is meant by this and how is this status determined?
Okay, so I can recall us having a number of people in our program who have been alcoholics for a long time, who have lengthy criminal records, who are before the court on very serious offenses such as robbery or serious violent offenses, which are likely to attract significant periods of federal incarceration, but they appear to be at a point in their life when they're ready for residential treatment services. And so through our readiness assessment and our risk assessment, we determine whether we think they're a suitable candidate for our program.
Thank you, that's great. Some requests to share some more resources, the paper that you referenced, your paper, as well as the assessment for readiness. So if you're able to share those either in the chat or you can share them with myself or Candace, and we can share them with participants if that would be possible.
Sure, we can do that.
That's great. Is there any indication as to when the second phase of the evaluation will be completed, and will that be publicly available?
We suspect that the funding proposals, well, the funding proposals are in, and we should hear back soon. whether we've been successful on those. And we're quite optimistic. So once we hear back on the funding piece, we'll then be able to get started on the second phase. And certainly I can forward our 5-year report, the 5-year evaluation, the 10-year report, along with our framework for a wellness court and our cultural assessment. And then I will speak to the clinicians about getting a copy of their readiness assessment piece.
That would be amazing, Chief Justice. Thank you. That's all the time we have for questions, but a lot of requests for those resources. So we thank you for sharing those.
Thank you for having us. Oh, can I say one more thing? I need to put a plug in. So
Yes.
Nova Scotia is going to be hosting a national virtual conference. It's September the 17th. It's a Friday. And the agenda and registration are going to be going out on the 22nd of March. And Candace has been so kind as to be willing to receive it and forward it along to folks. It is a conference that is, it's free. And it's going to delve into the unique and often complex cases that problem-solving courts deal with. So the first session will be on knowing your limits. No, actually, the first session was on nexus. Is there a connection between the offense and the mental health diagnosis? The second session will be on knowing your limits. You know, can you support the person in the program while still protecting the community? So understanding the limits of the program that you are working within. The third session is going to be interesting. It's on internet sex crimes, and it's entitled "Not All Sex Offenders Are Predators." And so it will look at youth who get addicted to internet pornography, turn 18, then become sex offenders, and how what steps might be taken to try and determine whether they're, they've got an addiction that is not a pedophilia, and ways that it can be addressed. And finally, the last session of the day will deal with cannabis and offending, and the effect of cannabis causing psychosis primarily in younger populations. So we hope that we get a good response, and we will make sure that we pass along that information for those who may wish to attend.
That's wonderful. Thank you, Chief Justice, and we will share that information with everyone.
Thank you, Your Honor. It's instructive to hear what's happening in another province, and it's clear that Nova Scotia has been very busy. Thank you very much for sharing your resources as well. We're now going to begin our first panel discussion on emerging issues in specialized courts. On your screens, you will see the following panelists. Robin Cuff, who is the manager of a variety of specialty concurrent disorder treatment programs at the Center for Addiction and Mental Health, CAMH. Jolene Highland, who is a defense lawyer and has been involved in Peterborough's community support court since its inception in 2011. Jolene has also been an agent for the Public Prosecution Service of Canada since 2017. Nicoletta Curson, whom you had the pleasure of meeting yesterday as a person with lived experience and a recent graduate of Toronto's Drug Treatment Court. And Kylie Holmstrom, who is currently the dual diagnosis diversion court support worker at the Canadian Mental Health Association Kenora branch. Kylie has acted as a support to Kenora's mental health court, which was started in 2011. And last, but certainly not least, is Jocelyn Boissonneau, who will be the moderator of this panel. Jocelyn is the Assistant Crown Attorney for the Durham Drug Treatment and Mental Health Court, as well as the Lindsay Community Court and past chair of the City of Kawartha Lakes local HSJCC. Please join me in welcoming Jocelyn and our panelists.
Thank you very much for that introduction. Our panel has decided to focus on 4 questions, and we focused on issues that we thought were emerging in specialized courts. The first question focuses on the 2019 Auditor General's report. This report on correctional services and court operations noted that mental health courts in Ontario lacked specific and measurable objectives and goals, and recommends establishing these. The report also recommends setting up best practice guidelines. The HSJCC report on mental health courts that Candace reviewed yesterday also recommended adopting best practice guidelines for mental health courts in Ontario. Starting with Jolene, Do you think that the ministry should establish a specific mandate, measurable goals, and or best practice guidelines for mental health courts in Ontario? If so, how?
Jocelyn, I think to answer your question, a general answer would be yes, in order to provide a level of consistency and expectations across the board. While at the same time, it's important to recognize that guidelines need to be flexible enough to meet the needs and limitations in each jurisdiction and individual program. It was interesting yesterday to listen to some consistent practices throughout the jurisdictions, while at the same time differences were discussed. And it occurred to me some outcomes that were discussed yesterday are not necessarily implemented in Peterborough on a consistent basis. And that's where I spend most of my time. And it begs the question as to how, we have participants across the board committing the same amount of time, doing a lot of similar work, and yet the outcomes can differ. And I think some consistent guidelines can help ensure equitable and fair outcomes for everybody. And also raises ideas that perhaps some jurisdictions haven't put their minds to. I think it'd also be interesting and helpful to have statistics gathered across the region in order to help highlight areas that need improvement, areas that are beneficial. And certainly that can help with assessing jurisdictions where there are higher retention rates for jurisdictions that have some problems in that area. And we can look to what is helpful and what's not. To answer the next question is how. I think one of the great things about these therapeutic courts is that it has opened the chain of communications across the jurisdictions. So there's already a good foundation to work upon. There's been some excellent research that is highlighted in the program materials, and that would provide at least a starting point. But I think it's really important that the ministry engage and make a concerted effort to consult with the various jurisdictions to appreciate the issues at hand and to have input in developing the guidelines.
Okay, thank you. And Robin, what about you? How do you view this issue, and do you have any suggestions on how the ministry could do this?
Sorry, I had to unmute. Well, yes, I think that having best practices is really important. But I also think that we have to consider the context, geographical and the supports that we have. So I think that what's most important is principles. So how do you define a mental health court, for instance? What is its character, and how would you recognize it? How can you tell it apart from other types of courts? So I think that getting at the values and the principles from which practices and goals can flow is probably one of the most important things.
Okay, and Kylie, you work in Kenora. How do you see this presenting itself by way of challenges, or do you have any suggestions on how this ministry could accomplish something like this?
Yeah, so just kind of echoing what the other two ladies have said today, I think there needs to be a specific mandate for what core basket of services are available to each mental health court. When I hear some of the other people talking about the mental health courts that they're with, I get kind of jealous of the supports that I hear that they have. Kenora's mental health court started in 2011, so it's been up and running for about 10 years. When it first started, we only had one court support worker and one forensic case manager. It wasn't until 2018 that we finally received a second court support worker specific for the dual diagnosis population. And that came through data gathering. For all the mental health courts to have an equal chance at being successful, I think there needs to be equitable access to the core basket of services. I think that there should be specific goals for mental health court when it comes to the foundational principles like data therapeutic jurisprudence. We need to be sure that we're using mental health courts in a therapeutic way that aims to increase the well-being of individuals who are using these courts. That being said, we also have to be able to work from a localized perspective because the communities across Ontario are so different. So we need to be able to have that ability to work from a local perspective to overcome our individual barriers.
Right. And we're going to get into that, the regional differences in our third question. So that's a great start. But now let's shift focuses a little bit. And my next question is about how a harm reduction and trauma-informed approach can be embraced in specialized courts to help define success. So in specialized courts, and perhaps more often in drug treatment courts, there can be a tension between treatment and justice, with treatment wanting to work with participants using a harm reduction approach, and justice trying to balance public safety concerns by maintaining structure in their program. This panel has representatives from treatment, from lived experience, and from justice. So I think it's really well positioned to discuss this issue. My specific question, and this time I'll start with Nicoletta, is how do you define success in specialized courts through an equitable and trauma-informed lens?
I think that is a very individual question. I think often we have this idea of success and it's very broad, but it doesn't take into account what is a certain individual's relationship, how they view their own success. So I think it's important to first primarily establish a sense of self-worth, and then focus on, as we were saying in the last question, I'm a big proponent of therapeutic jurisprudence. And for other types of crimes that may be more serious, I think restorative justice is a means of including victims in the process that is beneficial for both parties. I think drug treatment courts often place emphasis on being trauma-informed, as do many other services. So, however, this is typically, with language, trying to give people some sort of a sense of agency, but often I think this is, it lacks actual specialized trauma treatment. So I think it would be really interesting I'm going to sort of answer the first question along with this one. I think it would be interesting to have an advisory committee made up of peers, former graduates, and external service providers to talk to people and give advice to the team about client treatment and the goals of the courts. I think success is mainly recidivism. What are the rates of recidivism? And so that's in a criminal court context, but also the therapeutic value that people get out of their participation in the courts.
Okay,
I think,
sorry.
sorry. Just want to add one more thing. I think it's also important to get the police services involved more in wellness courts, just because they often have the first opportunity with the person they're arresting to maybe suggest or acknowledge that this person may be committing these crimes for a different reason. They often are present in communities. And so I think it's important to get them involved as well. But success, I think, should be defined mainly by the individual. Thank you.
Thank you very much, Nicoletta. And turning to Robin, I know you have strong views on this issue, especially as it relates to drug treatment courts. If we could have your thoughts.
Sure. So first of all, I know that you've heard me say many a time that we are in the business of redefining success. And we can set out graduation requirements and all the things that we expect of people, but success is very individualized. And success should be rooted in root causes, in social determinants of health, and should at least be partially and mostly defined by the client, not by us. And success is not about the gold star achievements. Success is about putting one foot in front of the other and quality of life. And as Nicoletta talked about, you know, the recidivism rates, well, I think we've gotten stuck in this mold of abstinence and no more criminal behavior, meaning success. And I really don't think that those are the indicators. Improvement in quality of life, establishing relationships, participation in things that are of value to us, reconnecting or connecting with relationships. Those are success factors, because you see that the absence of those things actually cause and perpetuate. But I will agree with Nicoletta that if we were to be able to break everything down, stop all the specialty courts and start from scratch, I would start with the trauma-informed and trauma-specific lens.
Turning to Jolene, in your role as an agent for the public prosecution in the community support court in Peterborough, has your committee discussed this issue, and where do you fall?
Yeah, I agree with what Robin said in terms of when our program first started in 2011, court defined success in terms of the rigid check boxes as to abstinence and community service or education and whatnot. I'd say over the past few years, we have reevaluated and at least started to open our minds to looking at success through the trauma-informed lens and recognizing that the treatment plans need to evolve over the course of that individual's course of treatment in the court program. Their needs will change, their access to resources are going to change, and we as the committee have to change our expectations as it goes along. It's a hard balance though, because you still have to maintain accountability in the program. And I think that touches upon the tension that you mentioned at the outset of this question, because there is a discord between how the courts have defined success and how an individual can see themselves as a success in the program. So it's a balancing act. And I think we're on our way to getting there in terms of balancing those factors, but it's one that is important to maintain integrity of the program amongst the courts, in the public's perception as well. And most definitely the participants that are spending their time and efforts in trying to rehabilitate themselves.
Right. Something that I've found helpful in my work is when we do multidisciplinary training on our team. When we hear from treatment about evidence-informed practices, and then also when we kind of explain to the treatment side how, you know, the justice side works, or what guidelines are that we have to follow. So I find that very helpful as well. And I think that we do evolve. And Robin, we've had a discussion before on this issue, and you talked about the differences between when the drug treatment court started in 1998 and today, and how treatment has evolved. Do you want to talk a little bit about that, and how whether or not you think that our courts have evolved along with the treatment?
Sure. So absolutely, I do not believe that the courts have evolved at the same speed of treatment evidence. And treatment evidence doesn't evolve as quickly as you might think, but much more quickly than laws get changed. So in the beginning, we worked with the understanding we had. I was actually a treatment provider. I was running a residential treatment program for women when the Toronto Drug Treatment Court started, and I was on the first advisory committee. And the types of things that we were considering at that point about success and expectations were pretty consistent with what was happening in the treatment center that I was running. But the evidence now is so much different. And so we have not revisited in a serious way those success indicators since the beginning of the program. And a lot of the programs across Canada adopted more or less some of our rules and some of our success indicators. So one of the big things is harm reduction, and how we view substance use, how we view harm reduction, how we are client-centered, how abstinence is not the only answer, how we used to look at substance use and lack of it as the main indicator of recovery, and it's not anymore. That is not the main indicator. In fact, people can stop using substances and still have all of the pain and a lot of the behaviors, a lot of the trauma, and a lot of the issues. So I think probably one of the biggest things is the focus on substance use. Also, how substance use has changed so drastically and has become more complex. When we started our program, it was part of the cocaine program because pretty well everybody in the program used cocaine or crack. And back in those days, when crack came, it's like, how are we ever going to survive this? And now the scene is so much more complex, and we eliminate and discharge people because we are working with old paradigms.
Okay, thank you.
May I jump in and just
Absolutely.
pick up where Robin was saying? I think harm reduction is a very important factor that should be implemented in these drug treatment courts or wellness courts. I personally took a path of abstinence, but that doesn't mean one size fits all. And harm reduction really is about maximizing quality of life and safety while minimizing risks and the lifestyle associated with use. So treatments based on abstinence, to expect that immediately or at all in some cases is a bit irrational. It's like if you went to get help for food addiction, sex addiction, fitness, online gambling, and social media addiction, nobody would tell you, well, stop using the internet, stop eating completely, you know? So I just think it is more logical to, harm reduction works well for many individuals. And I think it's just getting them to a point where their quality of life has gotten so much better, they're more sure, they're safer, that they choose to eventually maybe abstain. So yeah, I just wanted to add that in.
Thank you, that's very helpful. And Kylie, is there anything, how does your court in Kenora deal with the issues of harm reduction?
So our court works from a harm reduction base too. So basically like what Nicolette and Robin had said already is that like to define client success, that's not really something that we can do. It's really up to the client themselves. What might be success for one client might not be for another. So like one of the examples I have thought of and talking about the harm reduction. So success might be complete abstinence, like going away to treatment and abstaining from substances. Whereas for someone else, it might be using substances in a safer way. So that's kind of how we're addressing harm reduction in our court in Kenora.
Okay. And do you have specialized trauma-informed practices or trauma-informed therapy for your participants?
I know that like we do, so our court support workers, we do that kind of training, trauma-informed. We've done some Indigenous cultural safety training. So that kind of stuff.
Yeah. Okay, thank you. Moving on to the next question. So question number 3. Sorry, let me just find it here. So as we discussed in our first question, we know that there's a broad range of therapeutic supports and specialized courts, depending on the resources available in each jurisdiction or the funding that each court might or might not receive. We are really fortunate that this panel here today has a broad regional representation. So we have speakers from Toronto, from Northern Ontario, and the Central East. So first, to better understand regional differences that exist, can you please start by discussing the range of therapeutic supports in your court? And then can you let us know how you think we can ensure that therapeutic values are embedded in each specialized court? And we'll start with you this time, Kylie.
Okay, so I can speak from the perspective of the Kenora Mental Health Court. So we have 2 court support workers that serve the District of Kenora and 64 Indigenous communities from Treaty 3, Treaty 5, and some of Treaty 9. So since the beginning of our fiscal year, which started in April 2020, our 2 court support workers have provided support to 236 clients. And on average, our caseload is sitting at about 40 to 50 people. So this kind of leads into my next point, that therapeutic supports in each region should really be based on data and not just on population size. This is to ensure that the therapeutic supports are being operationalized in each specialized court. We need to ensure that we have the proper type of supports and the proper amount of supports so that we can give clients the time they really deserve so that no one's slipping or falling through the cracks. I also think we have to ensure that therapeutic values are embedded and operationalized in each specialized court, that we need to have trained and qualified individuals. And with that comes the funding for those positions.
Okay, and Jolene, you work in a smaller city in Ontario, in Peterborough. What types of supports does the community support court in Peterborough have, and what things do you think might be missing?
So Peterborough is a concurrent disorder treatment court. So we have a combined drug treatment and mental health court. I think it's very hard to separate the two. They're rarely mutually exclusive. So our group of court support workers include representatives from CMHA, Elizabeth Fry, Forecast Addiction Services, and an Indigenous persons representative. We also have other therapeutic supports in our multidisciplinary team that comes from the John Howard Society, Salvation Army, probation, police services. We have a psychiatric consultant who can do assessments for new participants. So I think, and we're a non-funded program. We have some funding from HSJCC, but it's primarily volunteer-based. And what I think is lacking, our multidisciplinary team had some training from my psychologist on the trauma-informed lens back in 2019. And I think it just hammered home to us about the majority, if not all participants, have some form of trauma in their background, and without access to the in-depth psychological support that they really require, is a huge gap, I think, in our treatment. And it all goes back to funding as well. But I think that's the biggest missing component for our court, quite frankly, in terms of adequately treating the needs of the participants to get the root causes of their criminogenic behaviors.
Okay, thank you very much. And Robin, is there anything you'd like to say on this point? And can you tell us a bit about the resources in your court?
Okay, so we're one of the fortunate, I guess, courts in that we did get federal funding, but it hasn't been increased in 20 years, and in fact it's been decreased quite a bit. So, but the fact that we operate out of CAMH means that we have a lot of other resources around us. So we have access to addiction medicine, and we have access to psychiatry and a lot of other supports. But we also, our clients are highly complex, and we also reach out to community supports. But I think in answering this question, peer support, we have peer support, and it's really, really important and really valuable. And I think that often when we answer a question like this, we start talking about training. And I think training and cross-training is important, but a means by which and a framework in which we implement that training, or we operationalize that training, is really important. So ensuring that we have something like maybe a team charter, or how we, and we don't have a team charter right now, but sometimes, but we've kind of developed an informal one, how we make values-based decision-making, how we bring in an ethical framework. Our little service at CAMH has probably consulted our ethicist more than most individual programs have, because it is hard ethically to work within this program. Consistent staffing and consistent values and wraparound services and focus on the relationship.
When you talk about consistent staffing, do you mean from the treatment side or justice side or both?
I'm talking about both. I actually think, even though it's really, really important in the treatment side, the treatment from our perspective, our treatment team has a bit of a wraparound relationship with the clients. So every therapist knows every client, does groups with them and everything. So if one person changes, the rest of the team can pick up on that. It is even more important that judges, crowns, defense, those people are consistent. It takes them longer to learn and to get into the rhythm than it does for treatment people around trauma-informed practices. I will tell you that every time a crown or a judge changes, the whole spirit of the clients and their freedom and their safety is impacted. So that consistency of people who aren't just appointed, but want to be there.
Nicoletta, from your lived experience, how do you see what Robin just explained in terms of consistency with the judicial or the justice players?
I think she's right. It's so important. And you can feel it in the court when somebody comes in that's, let's say, a judge that's not usually there. And everything, the vibe is very different, because I think you sort of build trust with the people around you. They know you, they know your history, they speak to you twice a week. And then somebody shows up that you don't know and that has never seen you before, that doesn't know your story. I'm sure they have some notes in front of them, but it's not the same feeling. And so I think it's absolutely vital, and on the treatment side as well. But as Robin said, they work together and they have meetings about the clients so that all the therapists are informed of what's going on. I did, while I was there, my therapist, she actually went on maternity leave for a year. And so there was, she actually found somebody to fill in for her for that year. And I built a very close relationship with her as well. And even though when that switch, I was still in a delicate place when the initial switch happened. And so I was a little bit on my guard, shall we say. But she was also wonderful. So I was actually lucky to have two great therapists while I was in the program. I would also like to talk about my experience the last time I went to treatment. After I was in the medical withdrawal unit at CAMH, I went to the women's inpatient unit, which focuses on trauma. And this is not typical in the program. Typically it's detox and then treatment rehab facility. And so that actually changed my life because I spoke to a psychiatrist 3 times a week about things I hadn't spoken to people about in 18 years. You know, so old traumas that I had been carrying around. And so it was vital for me. And I would love to see more of that. Although being trauma informed is very important to the program, I think specialized targeted trauma treatment is essential. And I think that's actually what's missing right now. And I'm sure it's due to a lack of funding, but also a lack of those supports, because I know after my success with that program, I had recommended it to some other people, and they happen to be men. So I was going online looking for trauma treatment for men, and actually there is not very much of that. And I understand it's because these came out of sexual assault, and that's why they're more targeted towards women. But it seems that they actually I haven't been able to find a single one for men that is particularly a program focused solely on trauma. So I think it really, everything comes down to trauma, whether, I mean, of course, there's mental health disorders, but when one uses substances and commits crimes, I think everything essentially comes down to trauma, whether individual or cultural, and so, or systemic. And so I think it's really important to focus and incorporate this into these specialized courts.
Thank you very much, Nicoletta. And Kylie, what about your court in Kenora? You said that you assist with a trauma-informed lens, but do you have specialized trauma counseling for your participants?
No, not specialized. We do, like through CMHA, we do have counseling psychotherapists. So if our clients are appropriate for that kind of counseling, we would refer to them, and they would probably have more specific trauma-related training. Also, our Lake of the Woods District Hospital has addictions counseling. So we kind of try to balance where we're sending clients to make sure they're getting the right kind of counseling or therapy that they're looking for.
Right. And what about your court? Do you have a designated judge or designated crown or defense or duty counsel?
We have a designated crown. For the most part, we have a designated judge. It can switch sometimes. It's usually the same kind of two. As for duty counsel, our court actually lost its duty counsel. I think it was a funding thing, and they said that they're going to only put duty counsel in there if we tell them that we have clients in there that don't have counsel. And then our clients all pick their own lawyers. We kind of tell them which ones we're familiar with or who are familiar with the mental health court, but really it's up to them if they want to pick from anyone on the list.
Okay, and do you see the benefits of having that designated legal team?
Yeah, I definitely think so. I think they really get to know the clients. They're not just like another file coming across the desk. They start to get to know what's going on in these court users' lives and starting to understand where they're coming from and why they got there.
Okay, thank you. And Jolene, what about you in Peterborough?
We have a dedicated crown. She's been there since the inception, and a dedicated judge. It's sometimes shared between the two, but it provides for consistency as well as there's been a concerted effort to maintain the same duty counsel and whatnot. So, and I definitely agree with Robin's comments about the training of the legal stakeholders in the treatment courts. There's so much to learn that obviously is not addressed in law school. And I feel as though with the evolution of our court program, we're learning through the participants, through the court support workers, everyone's expertise, and you can't really quantify that. I mean, that's years of experience, and to just switch, yeah, you definitely lose a lot of value in that.
Yeah. Okay, thank you. Moving on to our last question. We know that racialized populations are overrepresented in the justice system. Candace referred to a report yesterday entitled Racialized Populations and Mental Health Court Diversion. And that report found that marginalized and racialized populations face barriers in trying to access specialized courts. Starting with Robin this time, what are some of the inherent biases and discriminatory practices that form barriers for access and retention in specialized courts?
Thank you. This topic could take all day, and I think we've been given a little bit more time, and because it could be a little controversial and may sound critical, I did write a few notes down as well to give context to it. And I will talk more about race, but also about some other inherent biases. So we have a system that is steeped in practices that criminalize mental illness, addiction, brain injuries, race, poverty, illiteracy, cognitive impairments, and most of all, trauma. And I dream of a day when we don't have a need for specialty courts. But until then, I work to improve how we deliver services. I don't blame individuals. Every system has its brokenness. And certainly the health system is not excluded from that. And while I may focus on the justice system here, I am well aware that the system I work in is broken as well. I'm dismayed by how the justice system treats health matters and dismayed by how the health system treats criminal justice matters. Consciously or subconsciously, society's systems harbor harmful biases which are operationalized into discriminatory practices. Specialty courts exist to join systems together to fill gaps in the health and justice systems, and that work is tough and definitely not linear. It's so important that we not mirror or perpetuate the inherent harms in the system, but that we mitigate them and that we hold a mirror up to the system to reveal that business as usual just doesn't work. The question does refer to access and retention, and I don't want to lose that both are equally important. I believe that every time we lose someone or discharge someone, it's actually a serious incident and worthy of examination because retention is one of the major keys to success. So I want to just offer a few points, just kind of discussion starters or thoughts that we might grab onto as we process this both during this session and beyond. Unconscious and conscious biases perpetuate discrimination. Stigma is written into laws. And I'm sorry, but I need to stop my phone from ringing. Sorry about that. I turned off every phone but one. So we operate in a system that is wrought with systemic racism. And stigma and discrimination is written in laws, historical practices within law enforcement, and the justice system. There's ample evidence to show that, for example, Black and Indigenous people are arrested more often. They are profiled more often. They are taken to jail when approached by police more often. They are kept in jail longer. They are more often the victims of violence, and they are rearrested more often. Our legal system has had a very hard time pulling out of the grips of colonialism and white supremacy. At the very least, these factors all converge to make it more difficult to get into our programs and more difficult to stay. And it's well known and understood that our most commonly used risk assessments across many of these specialized courts have inherent biases and are not adjusted for race or ethnicity. Our language matters. Our language is embedded in culture and plays such an important role in how we view people. I often say how we speak about clients, we start thinking about clients. How we think about clients, we treat clients. How we treat clients, they believe about themselves. And if they believe they are hopeless and just make bad choices and they are difficult and they don't love their children and they need to be punished for being who they are less likely to be the candidate or participant we accept or keep. Even the commonly used phrase of they aren't a good fit for us. Isn't it important for us to make ourselves a good fit for them? It sounds like blame. We're blaming them for not being a good fit. Our understanding of drug use and mental illness has so much stigma and discrimination in it. We are more likely to be harsh or not accept or discharge people if we don't understand the significant role that trauma plays and the odd ways that trauma can play out in behavior. if we don't understand that most of our clients have a brain injury and aren't capable of doing what we're asking them to do, if we don't understand that social determinants are also core to why people problematically use, if we don't understand that mental illness and addiction are complex and there are layers of complexity that lead people to the point of committing crimes, and we need to embrace that complexity and not consider it a binary right or wrong matter. If we don't understand the role that pain plays in substance use, and we don't understand the role of substances in people's lives and people's absolute physical and emotional need, if we adhere to the old practice of this is just about determination and white knuckling it and just making a decision, ironically, the justice system often lacks the will or sees the need to consider a broad spectrum of evidence. Yes, I'll pause. Certainly, Gladue courts have started to do that. They look more broadly. But some values and judgments and methods are so deeply held within the justice system that we're not even willing to consider evidence that would change how we operate. We focus on punishment and what people deserve. And we have this paradigm of somehow punishment is going to make people better, and it doesn't. We get protective of what we've created. We don't easily accept criticism, and we see someone leaving our program as their failure, not a failure of our system. We perpetuate harms because we want to eliminate risk rather than assess and manage risk. If we were to understand that a person's actions are just their best efforts at the current moment, given their skills, knowledge, understanding, support, then it's just their best effort to try to get their needs met, then we might extend more understanding and patience and flexibility, and we might be less likely to stigmatize and discriminate. If we understood that while they are using and angry, they cannot use the logical parts of their brains, and then we might suspend our judgments. If we move beyond the abstinence only paradigm, and I don't say the abstinence sometimes or for some people, I say the abstinence only paradigm as the greatest indicator of success, and get them abstinent and fix the mentality without recognizing that addiction is often a chronic and relapsing condition, then we would realize that using substances is not a non-compliance issue, and we would stop discriminating and stigmatizing based on that. We would not set impossible bars for people to meet, and we would understand that harm reduction is client-centered and evidence-based and recognizes recovery as a lengthy process, which doesn't even end if someone stops using. And if we understood that relationship is paramount, that people don't typically change without at least one positive relationship, not criticism and punishment, but positive relationships, then we would understand that the concept of a judge is a judge is a judge, or any other discipline is just not true. Consistent people, consistent treatment will increase our retention.
Thank you, Robin. Jolene, just trying to draw on what Robin said there, and there was a lot there, Robin, so forgive me, but when you talk about, punishment and how that can perpetuate, inherent biases, discriminatory practices. I know that in some most drug treatment courts, they use sanctions and incentives. And Jolene, I don't know, do you want to comment on that and what you think about using sanctions in the drug treatment court context or specialized court context, and how that might touch on some of the issues Robin brought up?
Yeah, I think Robin has said a lot that I think takes time to really digest in a meaningful way. She raised a lot of good points. And going back to my comment about how our program has evolved, back in 2011, I remember, if someone had slipped up and a sanction was ordered, it was typically 2 hours community service and run along now and provide your proof when you come back. And we understood over time. Took us a while to get there, but some sanctions are now more reflective and treatment-based as opposed to punitive. So a sanction may be a reflection piece as to what motivated them to apply for the program, how do they foresee them getting to a place of, again, success that we talked about, and what do they need in the program that will help them succeed. And that was a more meaningful way to maintain integrity in our program, because you have to be consistent for the other participants who see a participant not in compliance with the expectations, but that sanction was a meaningful way to address behavior. And I think that's something that we'll continue to build on. It's being meaningful. At the same time, for incentives, it doesn't have to be a huge monumental success. Something so simple for one participant can really be a game changer, and to recognize that even it's being discussed about the relationship with the therapeutic court judge, and just comments by the judiciary to that participant about their success. You can see the pride that comes from the participant. We've had some participants just reduced to tears with appreciation and in recognition, being recognized for their self-worth. And that engagement is so important. And I think that's a positive shift that our court has evolved and will continue to, I hope, in addressing that.
And Nicoletta, coming from you and lived experience, how do you see these specialized courts addressing some of the concerns that Robin raised? Practical ways, maybe.
Well, just to jump on what Jolene was saying about incentives and sanctions, I think also it's vital that they're meaningful. I remember there were numerous times where I had piled on community service hours, and yes, I eventually went out and got them done and all of that. However, what I found was the best sanction for myself was a writing assignment. Now, obviously, I think this can be maybe any form of expression. It doesn't necessarily have to be writing, but engaging the person in a way, perhaps whatever their talent is, but also that makes them reflect on their behavior, their past and their future, and their intention and how they're going to move from the place where they are. And so I think, and then for incentives, there are various incentives. So one of them, as mentioned, was praise or applause in the courtroom, or gift cards. And I think maybe, again, instead of gift cards, there could be something that is more personal, because I think it's so important to notice a person's worth and strengths. And so I think maybe making it more individual in some way. And I think for client retention, it can be managed if the justice and treatment individual teams are willing to collaborate with clients, asking them, what do you need? I know there's a sort of idea of how the program is supposed to run. You know, in the beginning you go to groups, then eventually in the middle you go to detox and rehab, and in the end you're clean for 3 months or sober for 3 months, and then you can graduate. And so but I think it's important to ask the individual and give them a choice. Like, I remember when I initially started going to groups right away, but the group I was going to said that you couldn't use for 24 hours prior to the group, except the group was 5 days a week. So I just entered the program 30 days ago, and I was suddenly expected to not use 5 days a week. Anyhow, so I kept falling asleep in the group, and then I eventually had to leave. This was an external support, not through CAMH or DTC, but it was an external support. So, but I think it's important to listen to clients and also to expand eligibility criteria and have more flexibility there, because groups that are marginalized and over incarcerated are getting left out. So I just wanted to end my statement by quoting Soren Kierkegaard. He wrote, "The most painful state of being is remembering the future, particularly the one you'll never have." And I find that holds so true. There have been so many times where I thought to myself, oh, if only I hadn't done this, or if this hadn't happened, I would have had such a different life, a better life. And, you know, I was overcome with grief so many times that I eventually became hopeless. And I love what Justice Chief Cameron said yesterday about how these specialized courts are in the business of providing opportunity. And so I think it's important that we take more risks and expand eligibility criteria, and that we embrace the unknown to give people a future that they might have never had.
Wow, well, I think we might end on that note. And just before we do, sorry, I do want to just bring up, you know, it was interesting to hear from Chief Justice Williams earlier today, who it sounds like their eligibility criteria is quite broad. And she spoke yesterday as well about accepting people. I think she said 3 people had been accepted on charges of attempt murder, but robberies, break and enters. And I'm not sure that, well, certainly the courts that I work in Ontario we're not quite there yet, but it's lots of good, you know, lots of good thoughts here. So thank you very much from all of you. Really appreciate it. And Kylie, sorry, I don't want to, I was going to end there, but you didn't have a chance to comment on this last question. And I know working in Kenora, how do you feel that, you know, if are there and where do they exist, these inherent biases and discriminatory practices in your specialized courts or specialized courts in Ontario?
I think more so I was just going to talk about the barriers that our court has for Indigenous populations, because we do serve 64 communities. If they're required to appear in court in person, that could require flying in or driving significant distances. So it's a time burden, a financial burden for both the client and the family. We have such a small courtroom. It's 2 small benches in our mental health court before COVID. And our mental health courtroom only had phone access or in person. So there was no way for video access if we were trying to do that. So
okay,
that'd be my biggest comment.
Okay, thank you. I hope we have time for questions.
Jocelyn, you probably didn't see that we were given until 3:25, so we still have 12 minutes, which is why I took longer.
Okay, good. So we have 12 minutes for questions.
Yes, that's right. Thank you, panel and moderator. That was a very interesting discussion. Quite a few questions have come through. Feel free to keep entering those into the Q&A box. The first one, mental health special courts have accumulated great experience when mental health issues are prominent. Is there any plan to share this valuable experience with other judicial areas, especially human rights tribunals, when mental health disabilities have an impact in the case? And this person just says it seems that the HRTO, for example, is surprisingly lacking in their understanding of mental health impact and expected behavior.
I mean, I don't know of any, but Robin, I'm not sure, has CAMH been approached by any of these tribunals?
I'm not aware that they have been. Certainly if any of us were approached, we would step up to to help and educate. So I guess it's who approaches who.
Well, that's great. And there's the invitation for that collaboration. This question is directed for Nicoletta. Did you ever identify any need for separate gender-based services, either in terms of attendance at court, group counseling, meaning is there a value to separate female from male participants at times? And I know you touched on this, but would you care to elaborate?
Yes, certainly. I think it's vital to have groups particularly separate, and which we do at drug treatment court. So the group I was speaking of that I went to in the beginning, it was an external support, as I mentioned, because there is a relatively small number of women in drug treatment court, at least when I was there. And so now we do have groups, and we did at some point once a week in the afternoon. But when I first started out, they would send us to this 5-day-a-week support program. And it's simply because of the numbers, because if there are, let's say, 5 women in drug treatment court, and they're all at different phases, you know, some are going to graduate, some just started out, and then they don't all show up because either they're living their life or they're still in active addiction. And so it was difficult to actually have that court regularly through DTC. So they did send us to this external support. And it would have been valuable if I wasn't in active addiction and that the rule had been, no substance use 24 hours prior. But I do definitely see a need, and I'm glad that the Toronto Drug Treatment Court does this, where they do have groups, gender-based groups, and also therapists. My therapist was a woman, and I believe there's a male therapist as well that sees men. I think there are a few other women therapists, and I'm not sure if they see both genders or just men. But yes, I think it's really vital because there are some sensitive issues that you may not feel comfortable discussing with the opposite gender. And I think the same holds true for men. There are probably things that they wouldn't want to express in front of women. So I do think that's important, especially, in early or mid recovery.
Absolutely.
Court, as we do, it's not gender based. We all go to court at the same time, and I think that's fine because it's just like anywhere else in the world. I can't walk around the street without occasionally a gentleman or a person approaching me on the street. So it's the same thing in the court. It's just navigating our world. But yes, for therapy particularly, I do think it's vital.
Thank you so much for sharing that. A quick question here. Just wondering, how often do these specialized courts operate? Are they Monday to Friday? Any panelists like to weigh in on that?
I think it depends on the jurisdiction. In Toronto, I think it's, well, and I'll let Robin talk about Toronto, but the 2 courts that I work in, one is it's once a week, the Drug Treatment and Mental Health Court in Durham region. And then in Lindsay, which is a smaller jurisdiction, we meet every 2 weeks. And Robin, Toronto?
Yes, so we have since our inception been 2 days a week. Just before the pandemic hit, we were told that a day of court is being taken away from us. The mental health court operates 5 days a week. But our program operates 5 days a week. It's the court part.
Thank you.
Jolene?
For Peterborough, our community support court operates on the 1st and 3rd Fridays of every month, so twice a month for the designated court time.
And what about you, Kylie and Kenora?
We aim for about twice a month. Sometimes there's not enough availability and we'll have a few months in a row where it's only once a month.
Thank you. So yeah, you can see that it does vary quite a bit depending where you are in the province. Thank you. Another question here. Historically, individuals with mental health and addiction issues have strived to reduce stigma and to be included and not separated. How do specialized courts impact that? So I'm not sure if perhaps this person was thinking that, you know, these courts do separate people with mental health issues from drug treatment issues and from people in the traditional court system. Is that a good thing? Does that actually perpetuate stigma, or does it help to reduce it? Perhaps might be another way of phrasing that question.
Jolene, you were going to?
Yeah, so again, our court manages concurrent disorders. So we're addressing mental health and drug treatment issues together. I think the need for the community support court arose because these individuals were falling in between the cracks in the regular court process. So there was a need to have a separate treatment court. And I think that has enhance the treatment and requisite attention that these populations deserve and require. We are careful in terms of the language that we use during the course of the court appearances, the relationships that we build in order to try and reduce the stigma. And I think the collaborative approach has certainly strengthened that purpose. So I think it was developed to address that gap in those needs, and I think that continues to be the case.
Yeah, I would agree with Jolene. I think that rather than increasing stigma, having separate therapeutic courts just create an environment that are less stigmatizing. When you have a justice of the peace or a judge who has, you know, less education or knowledge about mental health or addiction issues, sometimes the language that's used, the way people are treated is extremely stigmatizing. And in these courts, I feel like we strive to have justice professionals who are more, or who are well trained or more in tune with the types of language that needs to be used, and also in just treating it's a more of a human approach. And I think that the regular court system is not a human approach. It's just you're getting people in and out, in and out. And so these types of courts kind of slow things down and try to reduce the anxiety and the uncomfortableness of those busy, intense court experiences.
Perfect, thank you. There's a question here about the Auditor General's report that was mentioned yesterday. Do panelists wish to comment on whether Ontario should develop a provincial steering committee similar to in focus to that in Nova Scotia, since the report did identify Nova Scotia as a model?
I mean, I think it would be great, but I also heard what Chief Justice Williams said yesterday, which is they're in a unique position because they are small enough yet big enough. Our province is huge and has, you know, great regional differences. So, well, yes, I do, but I think if we had a provincial steering committee, we would also need regional steering committees, you know, similar to the HSJCC actually, where you have a provincial and then you have the regional and then your locals, and then it all flows from there. That's how I would see it. Anyone else?
I agree with you. Any provincial initiative that's been rolled out has been wrought with complexity because of our size and our geography and the fact that we have this big monster called Toronto in it.
But I still don't think we should lose sight of the fact that there should be support at the provincial level from justice, from health, that will help, you know, trickle down, you know, the importance of these courts. And yeah,
how you structure it is important.
Perfect. Thank you both. Our last question is on financial support. So related to that last conversation, we've seen that it can be a restricting factor. What measures are being taken to secure more funding, whether it be regionally, provincially, or federally? And as a follow-up, if funding is secured, where should it be most directed?
Really good question. I mean, a lot of us are doing, we're doing this off the side of our desk, and we would love funding. And in the courts that I work in, if we did have funding, it should be directed, I think, primarily toward treatment and also toward, case management. So case management of the court, so that we can do the good work in terms of collecting data, evaluations, program, developing policies and procedures, program development, that kind of thing, and treatment. So I think it's program development and management and treatment. That's where the money should go. And I think it's needed, whether or not, I mean, there are different organizations that try to raise the needs of these courts to different governments, federally, provincially, all the time. But who knows? Anyone else?
We've tried everything and then we've tried it over again.
Yeah. I'm curious, Jolene, where do you think, if the funds were there for Peterborough, where would you see them going?
Treatment, absolutely. I just, there's so many gaps and so many needs of our participants that aren't really addressed. I feel like we're scratching the surface a lot of the times, and I would love to see increased funding to address the greater needs of the participants, absolutely. I'd be interested to hear Nicoletta. I know we're out of time, but I'd really love to hear from her.
I actually agree, treatment, because it's so complex, and that's, if there was funding, definitely that. There is a disparity of availabilities of housing services for men and women, again, due to the small number of women in the program, and then availability for that. And I think also in terms of somebody, Jocelyn mentioned case management. I think the goal is to have as many people as possible enter these specialized courts to provide them with the opportunity for a better life until the entire justice system becomes one of therapeutic jurisprudence. I think these courts are absolutely necessary, and as many, getting in as many people as possible. Thank you.
Thank you all. Those were all the questions that we had for this panel. So I'll turn it back to our co-chairs.
Thank you, Christine. And thank you, Jocelyn, Robin, Jolene, and Nicoletta, and Kylie, for your sharing each of your unique perspectives and insights on how we can better address emerging issues in specialized courts across Ontario. We're actually now going to take a 3-minute health break, just because we're running a little bit behind. And we'll see everyone back here in about 3 minutes.
Welcome back, everyone. It is now my great pleasure to introduce our final panel discussion, which is focused on the shift to virtual courts during COVID-19. On your screens, you will see the following panelists. Trudy Mouth, who is a criminal defense lawyer in Woodstock and has assisted many of her clients in applying to and participating in their local community treatment court. Julie Lavictoire, who is an adult mental health court worker in the Nipissing Mental Health Court. Julie is also the co-chair of the North Bay local HSJCC. Jennifer Lysay, who is a registered psychotherapist and addictions counselor at the Mental Health and Pinewood Center program of Lake Ridge Health and works as a treatment provider for the Durham Drug Treatment Mental Health Court. And lastly, but certainly not least, Marie Dufour, who is the moderator of this panel. Marie is the Assistant Crown Attorney in Ottawa's Mental Health and Drug Treatment Courts and has worked alongside Justice Heather Perkins McVeigh. Please join me in welcoming Marie and panelists. Thank you.
Sorry, Maria, you're just on mute. Okay, sorry, talking to myself. I'll restart that. Thank you. So for the last panel, we are going to discuss the shift to virtual courts since the pandemic hit the court system and all the court participants and service providers. I was actually in mental health court when our court in Ottawa was shut down the very last days, the week of the 16th of March, so almost a year to today's date. And there has been quite a few challenges, different, I think, now than what we saw initially. So be interesting a little bit to discuss what the challenges have been since the advent of this pandemic, basically since the last year. So I know, Jennifer, if you can tell us a little bit what has happened in your area and the Durham region since then.
Hi, thank you. We definitely, like everyone, had some definite challenges. I think overall, what I could see as an addictions counselor was definitely an increase in mental health in addictions due to the isolation of the pandemic. We've noticed as well overall increase in overdose, especially with opiates, increase in hospital admissions with regards to withdrawal from substances and stuff, simply because so many services were closed or are closed or limited, especially in our area, our withdrawal management, that has been gone from 22 beds to 8 beds. So that has been a definite challenge for us. I think other things that we definitely noticed was technology issues. Initially, we were doing mostly phone until our organization could establish rules around using virtual technology and so on and so forth. And once we did, it was from there transitioning clients who were so accustomed to coming into our office, dropping in, using our crisis services, to now use it virtually. What also was another thing is also being able to teach clients. But not only that, a lot of them maybe didn't have the ability to have cell phone services, or they didn't have the funds to use Wi-Fi or in that stuff. And even with virtual, as great as it is, that seamless process of being, sorry, I apologize. That process of being able to deliver the program seamlessly and being able to connect with clients virtually, especially, we definitely, again, initially, we started meeting as a team, and then virtually. And once the courts were able to meet virtually, we started our drug treatment court. We had started a little bit prior, but it was formally started once the courts were able to do virtually. So fortunately, we were able to keep in touch with clients. And what one of the things I will say is that because of the reduced barrier in regards to, say, transportation, our compliance was pretty good, and clients were able to follow through with most things. I think one of definitely the challenges would have been in sanctions. Incentives, we were able to mail that out to clients and such, but sanctions I think would be challenging to enforce, simply because there wasn't, other than, I know Nicolette mentioned writing an essay or reflective writing, which is something that we use. Other than that, there's no opportunity for clients to volunteer or participate in those kinds of things to no fault of their own. So definitely another challenge. And finally, I would also say there's a camaraderie when all of the clients attend drug treatment court together, right? And it's that simple thing of connecting with each other prior to court, hearing each other's stories, which they did get to do, but it's all of that small talk that helps to build up that sense of joining and camaraderie. And because we are doing that virtually, they don't get to have that same kind of opportunity.
And what about you, Julie, in North Bay? Have you seen something similar?
There we go. We have been experiencing some of the similar difficulties. Us most notably, though, I would have to say is that our local jail isn't able to meet the needs of the court. They haven't been equipped with enough phone lines or enough staff for us to be able to reach out to our clients that are incarcerated, or for counsel to reach out to their clients. There aren't enough video booths. In North Bay, there's only one video suite for court, whereas court will have about 4 different courts running at the same time. So it's quite difficult for our jail to try to meet those needs. Another struggle that I myself have noticed is that, you know, I'm a social worker, so we're in the business of helping people, and to be able to do that virtually, it's very difficult. It's tough to make those connections. Virtually, it's tough for me to be able to assess if my client is really struggling with their mental health, or if it's more so behavioral. That's all things that face-to-face we can better identify in our roles. You know, another challenge that I had noted was, of course, the technological challenges, right? I don't know how many times we've had sureties that come into court. They're not muted. We hear their dog barking. One time I heard someone go to the bathroom in bail court. Like it's the technology piece of even just being appropriate on video is a bit of a challenge as well. I mean, it does add a little bit of comic relief, which isn't something that we see too often in court, but something else that I was advised of from our local Crown attorney actually was that people are being released all over our district. They're being arrested in North Bay, but maybe being transferred out of district. And if they're eligible for bail, then they're being released wherever they so be, which sometimes it's from Sault Ste. Marie, which is 4 hours north of where we're located. So it falls on maybe the hospital or the Crown Attorney's office to try and figure out how we can get our clients back to our community. So those are some of the main challenges that I myself have faced during virtual court.
Just one thing on that. Have you had any challenges also since the court has resumed in August of 2020 with more virtual court appearances for specialized court participants? Have you had issues with those persons out of custody trying to appear in court in terms of technological challenges?
Yes, absolutely. I mean, it's what I'm going to be speaking to next, but we've been thinking outside the box as to try to find get our folks back involved in court. And so, yes, being able to connect virtually with the technology, access to a phone is something that most of my clients don't even have, much less a laptop to be able to do it virtually.
And what about you, Trudy, where you are? Have you had the same challenges? I mean, I know you're speaking from your position as counsel for many of the court participants. I think you might be muted.
And I am, sorry about that. So I practice in Woodstock, which is a small town, approximately 40,000 people. And I'll have more to say about technological challenges later on. Right now, what lawyers are finding difficulty with is getting access to their clients at the jail. Visitors are extremely limited, and getting in touch with our clients via phone is extremely limited. Because of various lockdowns that have been going on at the facility, it sometimes is, they're not allowed to use the phone every day. They have to use the phone every third day. So then they're in a lineup with 20 other guys who also have to use the phone within a span of an hour. So that's been really difficult to keep in touch with our mental health clients, because what we want to know is, are they taking their meds? Are they being able to see a psychiatrist, et cetera? And I found that to be very difficult. That's a challenge for all the lawyers, I think.
And have you seen, as Jennifer was indicating and Julie were indicating, some challenges with persons who are incarcerated and having access since the pandemic took hold of the court system? And
exactly. And in addition to not being able to speak to their lawyers, CMHA workers are also telling me that they are trying to get in touch through the social worker at the jail, again, to work together with me with our mental health clients, and it's just been extremely difficult. So that's been a challenge for sure.
And speaking to these challenges, I know we were looking, of course, that things have changed over the course of the last year, and there's been some, thinking caps being put on and some innovations and accommodation that have been looked at to try to address those issues. Have you seen anything, Julie, that you'd like to put at the forefront in terms of what innovative solutions that you've come up in your area, or that your colleagues have come up in your area during the pandemic?
So our released from custody workers are equipped with a laptop and a cell phone that they use as a hotspot. And so they'll go downtown, they find our clients, and they make sure that they're calling into court. So I thought that was really inventive on their part, was just to be able to use their phone as a hotspot to get things moving that way. A lot of times our low barrier shelter staff reach out to me, they have a client there, they don't know what's going on with court, they haven't been able to reach their lawyer. So I've become the liaison between clients and counsel, which has proven to be a little bit more helpful. We're also using the chaplain and the social workers inside the North Bay Jail a lot more frequently, like just I think it was Monday, I needed to assess the need for a fitness assessment, and I was able to contact the chaplain, who was able to connect me with the client inside the jail, which is great. The sergeant wasn't available, and so it's just to kind of think of who else is in the jail and who else could we use to kind of help out. We're also in bail court. We open up our virtual bail court about an hour early every day, and it's off the record, which allows counsel, workers, and Crown Attorney to speak off the record to kind of, I'm not sure how it worked in other districts, but I know in Nipissing District, when we'd walk in the morning, we could chat with everyone, and when court would start, most of us would have a plan as to where we were going with our clients. And that was something that was really missing since COVID started. We couldn't just go down to the cells and chat with our clients and connect with counsel and Crown upstairs. So to have that virtual court opened off the record has been really helpful at getting things moving in bail court. And I also anyone that will hold on to my business cards, I've shared them with them so that it's at least one point of contact that they could have involved in court. Even if they're not on my client list, I'm happy to assist to try to get people moving through court.
And have you had any complaints in that? And what solutions have you looked at that for people having access to services once they're out of custody and once the bail stage has been completed?
So our release from custody case managers are typically picking up clients still at the jail upon discharge. And we haven't noticed a significant decrease in services in our area. We're still quite connected. We're a small enough community that most of us know personally the other people, other service providers that we are trying to work with. So we can reach out to them and say, I need to connect with you guys right away. What can we do? And so thankfully, there hasn't been a significant impact as far as services that are available.
And turn again to you, Trudy. I mean, you spoke about your jurisdiction, which has about 40,000 people. What have you seen in terms of accommodation or solutions that have been, brought to address
similar to
pandemic issues?
Julie was saying, if when we're calling the jail, we try to be inventive as to who we can connect with there to get the message to our client, although we won't be able to necessarily speak to them directly. We may call the chaplain, we may call the social worker, we may call the infirmary if we happen to know someone who works there. So we've had to be creative in terms of doing that. And the reason why, of course, is, you know, if we're working on a bail plan and I only get to speak to you every third day, I need surety names. I need to call them. I need to set up the bail plan, et cetera. And for each day that that person cannot talk to me, that delays and keeps them in custody. So the other challenge that Julie raised, which is also relevant in our area, is our jail is about half an hour away. We don't have anyone to return individuals who are released from the jail to come back to Woodstock. That is a gap for sure in our jurisdiction.
You spoke about reaching out as you know, as best you can to the jail to have this access to the client that's more timely. Does your jail have a mental health unit that you can contact?
Not that I'm aware
to facilitate such calls? No way. Okay. I know I didn't ask you that. Julie, do you have a mental health unit at the jail that can facilitate such contacts?
No.
Okay. And what about you, Trudy, in your, Jennifer, in your area?
So in our area, I think our biggest challenge was definitely technology. So we were able to, through the hospital, provide some clients with cell phones. And like I had mentioned earlier, another issue was definitely overdose withdrawal type situations where it was we were really overwhelmed with that. So once we were able to establish some protocols, we were able to open up on an emergency needs basis and as well as provide that support to clients through various other services. For example, our withdrawal management or our rapid addiction medicine program, we were able to provide that kind of, you know, getting clients established on Suboxone or assist them with any kind of withdrawal from alcohol and that kind of thing. The one thing was initially in the pandemic was all of the community services in our area came together to create one service called Mission United. And it was really targeted that population that's very transient and would not be able to access simple things like going to Tim Hortons to charge their cell phone. So through this service, they were able to set up a hub where individuals could go and charge their cell phone, connect with social services, connect with withdrawal management, harm reduction supplies, financial services, and various areas in one place, as well as food, a food pantry as well, so that they could access that, which I think, and hopefully it will continue in our area, as we did have it before, but it was scattered throughout the Oshawa area, and now it being localized into one area, I think it's more user friendly for clients. So that too. And the other thing I'll also mention is the barrier to treatment in regards to transportation. Especially for drug court participants, it was removed. It was, we weren't seeing that. I couldn't make it because of the weather, or I couldn't make it because of my car broke down, or I missed the bus, or so compliance has actually been really good, because that barrier in regards to getting places, once they were established with the technology, was removed. So that it itself has been a benefit.
Can you speak about technology? I know in our area in Ottawa, things are getting a lot better in terms of access to technology than at the very beginning of the pandemic. But Jennifer, do you still see that as an issue, for example, for your drug treatment court participants, and that there have been some accommodation by the program made in terms of accessing various technology to be able to participate remotely to the various endeavors involved in that rehabilitation program?
So I initially, yes, I think when participants first join, it's that learning curve that we have to explain to them how the program works and the program that we're using, and getting them, especially if they're not computer savvy. So getting them familiar with setting up an email address and those types of things. But once they figure it out, they seem to be able to, it flows well, as long as the internet is working, Wi-Fi is going smoothly, and we don't have any of those glitches on either side. It seems to be very user-friendly. Now, there are some challenges in regards to, if we're doing a group and if someone may be smoking, or simple things like, triggering things in the background, like a beer logo or something like that, right? But I feel it's easily addressed, especially if it's a simple phone call to a client, so that it's not being done in front of the group because the intent isn't to embarrass them. So yeah.
And in terms of programming, and that question is for all of us basically, when the more clement weather will come, do you see any difference in terms of innovative solution that might be thought of in terms of accessing and delivering programs and services, either on an outdoor setting that cannot be done right now?
I personally would say only if there's a need. I feel right now it's running smoothly. And so at this point, I don't know that there's a need for it, but definitely if it's necessary. And like I said, we are able to see people in an emergency basis following all protocols. So it would definitely be, access to them would be easier.
And do you see the same in your area, Trudy? Is that something that has come up as a solution, perhaps?
I agree. What Jennifer also mentioned a moment ago is one of the good things about technology is that our clients can now access, say, counseling, etc., online. And my clients often tell me, yes, I'm talking to my addictions counselor online. And that's all well and good, but I also have some clients who don't have access to a computer. So I think we all take advantage of the fact that we have cell phone with data that works, and I'm not boring my friends, cell phone, and I have a computer. But without all of those things, keeping in touch with CMHA and doing all the things that are set up for their treatment plan are often very difficult.
We have seen, yes, we have seen, I'm not sure if the echo comes from me, I apologize. So we've seen some challenges, obviously, and there still remain some, and also some innovative solutions to some of these challenges. But, looking to the future, if we, it seems like we are remaining in, at least for, the next few months, in a virtual world, and then perhaps this virtual world will remain in some fashion. What would you see as necessary, or hope, that what you would like to see, and hoping that matters could improve and could be optimized in terms of access to specialized court, and also various mental health, addictions, concurrent disorder programs in these in these times, and looking to the future after the pandemic is hopefully done. Trudy, have any thoughts on that?
Yeah, so our CMHA has been great in terms of getting cell phones for the clients, as I indicated. In order to continue access, however, particularly with Zoom, we're going to need a place where our clients can get access to computers. So whether that's at a CMHA or some other service provider, it used to be that my clients could check their emails from me or others at the library using their block of computers. But with COVID, they're limited hours and they were closed for a period of time. So we've had to think of other ways that we can get access to computers. So I think COVID has really shown us how much we're dependent on technology, but I think we just always have to be reminded that our clients, particularly in the mental health courts, don't have all of those advantages, and we're going to have to think outside the box in order to get them to be able to participate in what we want them to, and participate in court as well, which is what we want.
Have you seen also, either some issues or something that might need improvement in terms of your clients being able to access their disclosure in a timely fashion in these virtual times?
Mm-hmm. So unrepresented people who, eventually come and see me once they get legal aid, etc. Right now, disclosure in our jurisdiction is sent out electronically, which is very handy for us who have computers. But again, an unrepresented individual with no computer, there's no email address. So there's a time delay, I expect, in contacting the Crown's office and saying, well, you can't email it to me because I don't have one, then they have to mail it out, etc. So there's a lapse in time, and there's a number of adjournments in court where it's time lost because they wouldn't know necessarily that the Crown screening form has said from its inception, this is a person who's probably a good candidate for the mental health court. And they won't have known that because of just sort of this logistical challenge. But then eventually when they get legal aid and if they come and see me, it's just slowed down the process somewhat, again, because they don't have access to that technology.
We've seen, I know in the earlier on, we've discussed, some of the perhaps some advantages in terms of virtual access to services, that there's no issue of travel time and difficulty traveling to the service provider. Have you seen some of that as well? And again, it ties into how we can better optimize that for some of your clients appearing in specialized courts, either whether it removes some anxiety of having to travel to the courthouse, waiting several hours to be heard.
For sure. Back when we used to have to go to court personally, a number of my clients would often say, I don't have money for a cab to get to court today, or I have to rely on my buddy to get me there, so I'm going to be late. So you're right. I mean, now it makes it a whole lot easier for people to participate in court because they have cell phones.
Is that something, Jennifer, that you see as well in your area? Have you faced the same, not face the same challenges, but basically have you seen the same thing, and what could be optimized from your standpoint?
I feel if we're in our area, we're fortunate with the clients that are presently participating, but yes, definitely we have that population that like I said, are very transient, and to Trudy's point, don't have access to technology or computers and would use the library as well, right? So looking to even set up a hub where they can access that, right? Where it's specifically just for that. We are so reliant on it. Even pre-pandemic, I think we were really reliant on it, whereas I'd have many clients going to social services to use their computers to look for jobs and stuff like that. And all of that has gone. So, but I would, with that, for being able to make sure that people have the basic means to access technology, I think making it more user-friendly for all treatment providers, lawyers, whoever, would be, I think, a benefit, because I can say for myself, a majority of my time since the pandemic started has been helping clients get access to the stuff that they need, or simply like a letter, right? Being able to email that and the process for that. And it can be a very overwhelming thing. So just making it more user friendly and removing all of the red tape and all of the requirements that pre-pandemic, when we could see each other face to face, looking at that now in regards to services and removing some of that red tape or some of the barriers that were in place. And with that, I talk about stuff like signing consent forms, or just taking that verbal agreement and not requiring certain things, so that it makes it less challenging for that, especially for that person that doesn't have access to technology. It makes it more easier for them to move through the process.
And do you see something similar, in your area, Julie, for the time being during the pandemic and for the future?
Yeah, absolutely. I think we're all experiencing similar things with our clients, and ways that things that I've thought of that maybe we could improve access to courts. So I thought perhaps all ground level frontline workers, thinking like our low barrier shelters or the employment centers, could all be given some sort of tablet, iPad, something with a direct link to court, so that it's just there, and folks know that if I'm walking past this place, I have court, I can go in there and access court. Furthermore, I think MAG could improve their social media presence. I understand it sounds kind of silly, but a lot of people access social media. A lot of people use Twitter and Instagram. And if you're trying to reach out to a certain type of people, it might be helpful to reach out via social media, so that through word of mouth, people can find out that, you know, court's now on this day, or and I think social media presence by MAG would be a huge improvement. I'm also feeling that the fail to appear charges may not be very useful at this point in time during the pandemic. You know, issue a warrant, absolutely, but maybe leave the fail to appear charge behind. It seems unnecessary at this time, and it's just adding extra lines to an already very full docket. And speaking of dockets, my last point of trying to improve access to virtual courts would be perhaps to separate different, so our first appearance court, our remand court, it's running until about 8 p.m. now every Tuesday. So our clients that haven't been filtered through to me are waiting, using minutes on their cell phone that they've paid premium price for, waiting hours and hours on hours, so that they don't miss their chance and get a warrant and a new fail to appear charge. So I think maybe separating the courts, the first appearance courts or the remand courts, to just a shorter day. I like our clients are spending about $30 to do a court appearance, which is 10% of their monthly budget, which is shocking.
And once they leave the first appearance court, does it improve if they are, you know, going through a specialized court, or their special court appearance time that they're given in advance, or
yes,
how does it work in our area?
Yes, once they're connected with myself, a specialized court, then they're able to have a little bit more of a concrete time that they attend to. But it's that first, and I'm thinking outside, not just the specialized courts, but even just for regular court folk, to just those remand courts are awful right now. 8 p.m. is really, I just think of the poor court staff that's still running at that time. So,
and if I can just add to that, that might be their first appearance where they're waiting a long time. If they're able to retain counsel, get legal aid to do so, then we will get them a designation to sign, which allows us to appear for them so they don't have to. But how do we get a designation to someone? How do we scan and send it to someone who has a computer but no printer? So then we send it through snail mail, and, you know, it takes time to do that. The other thing I wanted to mention, if I could, Marie, was when you had last asked me about, you know, people feeling more comfortable with technology. I do have clients, of course, who are terrified of the notion of appearing virtually or on the phone, because like me, they're challenged and when it comes to technology. And so knowing how to use their mute button is something I had to teach them. Or people who don't do much on a computer, it's very difficult to try and assist them in navigating a Zoom type program to be able to participate. So yes, for some, it's very handy and it's easier, but I think we also have to keep in mind the other clients that we have where it's more of a challenge.
Or even I have some clients that don't believe that this is really court. I'm not sure if anyone else has experienced that, but I've had quite a few clients that I've tried to get them to plead, and they don't believe that they're sitting in a court because they're sitting in my office. So it's the clients that are really struggling with psychotic type illnesses, I find, are really, really challenged by this, by the virtual courts.
We've had the same in Ottawa, and you know, we've had some resolution days where we resolve mental health matters, and they are only in a court only for mental health matters. And I've had some participants that had to watch some resolutions before setting their own dates, but the hurdles usually have been overcome for all of them in terms of, you know, gaining a bit of confidence that this is real, and it's, you know, it's a process that runs quite smoothly. And we've been very fortunate in Ottawa. Things have run quite well in terms of those resolution days, but that has addressed, but it takes quite some time for their support, either from CMHA or other service providers, to be able to assist them, and, you know, setting them up to be able to watch, and then setting them up again with assistance to be able to access the court on their resolution day. And it takes some time, but that's something that, do you see maybe improving with time? Either with allocation of resources or access to technology from various hubs or various locations?
I think it will improve over time. It's even odd for me to be attending court from, unfortunately, my bedroom during COVID, right? It's odd for all of us. So, but it's becoming a little bit easier. So I imagine it'll work that way similarly for our clients as well.
And do you see the same thing where you are, Jennifer?
I do. Initially in the beginning, there was definitely a lot of challenges, but once, I think the biggest thing was in the beginning, there was that lack of PPE and such, and as well as we needed a period of time for services to reorganize themselves and figure out ways how to deliver the same service, but virtually. And once services were able to figure out ways to deliver the service properly, it seems to be getting better, but yeah, there are still a lot of gaps in the system.
And CMHA in our area have been great in terms of court appearances. They've been able to have the clients come to an office, a large enough office there where Zoom captures all of the participants and they're spaced accordingly for COVID. That has really helped. But again, well, Woodstock's a small town, so generally you can get yourself around. You don't have to do too much in the way of transportation, but it's not as easy for those who live out in the rural communities and having difficulty getting downtown to CMHA. But we're thankful that they have that.
Thank you. Before we turn it to questions, because I've seen quite a few questions popping up, anyone would like to add something on these topics?
The only other thing I wanted to add was we mentioned that having a hub of computers, et cetera, would be very helpful at certain places. And I think then we have to turn our mind to confidentiality, because yes, I know you're in an open courtroom when you're in community treatment court, but that's all we have in that court. So it's not very busy as a regular courtroom would be. So we just need to turn our mind down the road to, if there's 15 computers and you're speaking to a judge about, you know, personal things and your successes since the last court appearance, how do we make that so there's some privacy? I just throw that out there.
Yeah, and this has been an issue in our area as well. You know, obviously trying to find some solutions, but respecting the privacy as well, which is, yes, not an easy task.
Agreed. And even with, from a treatment provider's perspective, when we're doing virtual, we have to ensure that they're in a place that, you know, it's private. And especially when we're doing groups virtually, right? We have to look at not just the client, but the whole entire group's confidentiality. So I definitely agree.
Thank you. Candice, I don't know if you want to open it up to questions at this point. Trying to be mindful of the time as well.
Yeah, Marie, we certainly have, you have 10 minutes for questions, so
okay,
feel free. Christine can look through the Q&A box in the chat and go through some of those for you guys.
Thank you.
Thanks, Candice. Thanks, everyone. Our first question here: what has the pandemic forced us to do that we might actually consider perpetuating as part of the post-pandemic new normal?
I think our folks on the ground with their laptops and their phones, I think would be something great to keep going, because pre-pandemic, a lot of our clients that struggle with homelessness and addictions weren't attending court, but it happened frequently enough that I drive downtown, grab a couple, put them in my car and get them to court. So I think, you know, the whole people on the ground level with computers and a cell phone is something that we should definitely keep handy for virtual court and moving past COVID virtual court. I also feel that a hybrid would be
a good option down the road, so that it gives clients who don't have access to technology the ability to meet with someone or face-to-face or come in, but also still continuing that option if they want to access virtual, or if they have the ability to, then that would be that beneficial piece, because again, it's a barrier that I find in treatment is huge to why people don't attend services or see screens or whatever it is that they can't make it to.
And I know it's been the same a little bit for us in court and the virtual on these resolution days that we've set up with set times. You know, we could accommodate the persons who have difficulty waking up in the morning, either the medication have, you know, not allow them to wake up early enough to make a court appearance at 9 or 9:30, and they're better you know, apt at being fully participating in their matters in the afternoon. We've been able to accommodate that in court with some set times that we could not before. And then again, you know, your commitment is a lot less, you know, I mean, it's a lot shorter during your day to be able to zoom in at a specific time for about 20 minutes or half an hour instead of having to travel on public transit for hours and then waiting in court. So that is some of the comments that I've had from some service provider in my area about their clients. So that's one of the, I think one of the pluses that we've seen with virtual courts that were not there before.
That's great, thank you. Another question here about confidentiality, and I know that you have touched on this, but you know, in terms of safety for people accessing court virtually, and as well as confidentiality, what can you share about some lessons learned or your thoughts for moving forward?
I know for, I'm not sure that's going to answer the question properly, but I know for us in Ottawa, I've had some concerns in some appearances where I've had participants who were appearing from a convenience store, because I could see the background, and you could hear the noise around, and you know, I kindly basically ask the court to inquire whether, you know, it would not be better to have an appearance where they could have access to a location that is not as public, especially when, you know, some medical and mental health reports are being discussed. That was a concern. Some other persons appearing from their car, where you could see some other passengers in the car that were, you know, not known. So that was, you know, there was some, and I don't think, I think a lot of it is, you know, persons are not made aware really of what the issues are, and when they are, then often for us, I mean, they've, you know, agreed to reschedule at a time where they could have more of a private space without any issue. But that is something I think that, you know, I'm more alert now that I've seen this guy in the convenience store surrounded by cans and a lot of people walking by. Now I'm always, you know, being a bit more attuned to whether the privacy is you know, something that is compromised by the location they appear from.
From the treatment perspective, confidentiality is in key with us in what we do. So when they come into the program, they have to sign, they come a waiver through drug treatment court, but through coming into our treatment services, they also have to sign a confidentiality, and we take them through step by step what confidentiality is and the importance of not doing your session in a convenience store or stuff like that, because a lot of times they're just not aware of their surroundings or the idea that, oh, I didn't realize this was a not a good idea, right? It's just convenient. So I think we take them through that, and we take them through that as if, you know, service in regards to what we would do person to person. But now that we've started virtual and email, we also take that into account as well. And we go through another type form with them. Just simple things like, you know, we ask you not to be in a room with other people, or we ask you not to record this as it's not permitted. Simple things like that, that they themselves wouldn't think of, right? Oh, I just did a screenshot of the information, but on that screenshot, there's everybody's face and name. So taking them through that step by step, I find it brings about their awareness that they may not have had in the beginning.
I agree with that. And also what lawyers also have to be cognizant of is that everything that you say to your client is absolutely confidential. Sometimes it just takes a short conversation with them earlier to make them aware that, no, it's not okay to put your cell phone on speakerphone at home while we're having this discussion. And no, it's not okay for your best friend to sit next to you when you're doing it. So they've been very good about that when we've called them and said, we want a specific time to call you or to Zoom with you. And it has to be, try to be in a room by yourself. It's very important no one else hears us. Generally speaking, they've been good.
That's great. Thank you, everyone. Another question about funding. If there was more funding available, how would you direct that funding, either during COVID or moving forward?
I'd get some new phone lines set up at the jail. I would try and help out my friends over at the jail with some more staffing. And also minutes for cell phones. It's a big one, because our agency, yes, we have a bunch of old cell phones that we can give out, but they need money to put minutes on it. So yes, I think sounds like Bell would get a lot of that funding.
Well, in terms of funding, a mental health unit at the jails would be great. It would make our lives a lot easier in terms of getting access to our clients regularly, because they're vulnerable. They're vulnerable at the jail particularly, and it would be good if we could get in touch with them a lot easier.
I think for our Durham Drug Treatment Mental Health Court, for us, it would be to, and just to echo what Jocelyn Bosno had said, just a dedicated person to run our court. Right now, we're unfunded, and we do this on top of our regular jobs. So by having that that ability of one person, it would allow us to increase our numbers and be more innovative in some of the stuff that we could offer to participants.
Thank you for sharing that. And I just see a comment here in the chat that many of the jails do have these mental health units. For example, EMDC does, and there is a social worker available there to assist with phone calls, just for everyone's information. So that's the end of the questions that I have in front of me here. If anyone has another question, feel free to enter that in the chat. We do have a couple minutes left. I'm just seeing here, there's a resource for those phone minutes with the Bell Let's Talk card. So maybe they would be open to donate. It's true that they do have that campaign every year. So that might be an opportunity to, instead of giving money to Bell, asking them to give back here. So I'll turn it back to the panel to see if you have any final thoughts you want to share about, you know, how COVID has really maybe changed the direction of your court, you know, and how you might incorporate some of those changes as you transition back to in-person operations.
I was going to make a comment, not so much related to what you said, Christine. I hope that's all right. But I think something that wasn't discussed so much was the compartmentalization, the difficulties that us as workers and counsel and Crown are struggling with. Like, yes, our clients have struggles, absolutely. But us as workers and staff in the courtroom, we also are having our own struggles. It's really difficult to compartmentalize and to walk away from hearing the chaos that we hear in court and then to just walk into your kitchen, you know? And so I think just to be mindful of some self-care tactics as workers in the court too, that we discuss these things with our clients, but it's really important for us as workers to take care of ourselves so that we can be there for our clients.
To follow up on what Julie was saying, yes, a colleague of mine recently coined the term as Zoom burnout, and it's just going from meeting to meeting, session to session with no break in between. And if you think you were in person or in your office, you would have that break where you'd stop and speak to a colleague, or you would just take a minute, but you don't have that because, you know, you click off at 2 o'clock or 1:59, 2 o'clock, you have your next appointment. So yes, that increasing that self self-care and just taking some time to break from the computer, and also not feeling guilty about it, because if we were in person, we would take that time. It's incorporated into our day.
I'm smiling because I think I need to take a lot of lessons from that, not jumping from one matter to the other without any break. But I think that's the, that's the trouble a little bit. And I think it gets me to reflect that it comes with trying to keep, the specialized courts from derailing a little bit, especially for me in the mental health court, to really try to get everybody engaged. And when we don't meet in person, it requires a lot more work in seeking the input, getting everybody connected, and ensuring that the persons don't get lost in the process, and their cases are treated as they were before and with the same importance as they were. So I think you lose a bit track of time and the efforts that are put in, but yes, I think self-care is probably something to focus on as well.
Thanks for that. And there is an anonymous comment here in the Q&A. Take care of yourself. Remember that you are not working from home. You are working at home during a crisis. You are at home during a crisis, trying to work. So that is a great reminder and a great way to end our session. So thanks to all of you. I'll turn it back to the co-chairs.
Thank you, Christine. Thank you, Marie, Trudy, Julie, and Jennifer for that wonderful discussion. We very much appreciate you sharing your experiences and innovative approaches in continuing to serve our client populations during the pandemic and beyond. I would now like to introduce our final speaker for the day, Assistant Deputy Attorney General Susan Kyle. Ms. Kyle assumed the role of Assistant Deputy Attorney General, Criminal Law Division in April 2017. She began her legal career as counsel in the Crown Law Office Criminal. She subsequently served as counsel to the Assistant Deputy Attorney General, counsel to the Deputy Attorney General, Executive Legal Officer in the Office of the Chief Justice of the Ontario Court of Justice, Executive Director of Justice on Target, and the Founding Director of the Ministry's Analytics Branch. Ms. Kyle and her ministry have continued to demonstrate their support and dedication to the important work of the HSJCC network over the years. Welcome, Ms. Kyle.
Thank you so much. And thank you very much for inviting me to provide a few closing comments at this important forum. I'd just like to note that I have been able to sit in through quite a bit of the last 2 days, and I've found it extremely informative, and I've been furiously taking notes and really carefully considering a lot of the challenges that you face. So I want to thank you for your really excellent program, and commend you for pulling this off, especially during the times in which we find ourselves. So thank you. Despite the challenging time, so many of you took the time to look forward and to learn from one another, investigating promising practices from other jurisdictions, discussing best practices, looking at emerging issues, and really considering the impacts of the shift to virtual courts, which has been challenging for all of us. There's no question, but particularly when you are dealing with such vulnerable clients. We know that the approaches and processes used in specialized and therapeutic courts by judges, crowns, defense lawyers, community support workers, and other professionals can affect the well-being and the outcomes for those who come before these courts, improving both access to justice and the ways that the justice system responds to mental health and addiction issues in the criminal justice system. So, while the history of these courts really only dates back slightly more than 2 decades, the progress and the innovations made in these courts over these years has been impressive and significant to the needs of the communities in which they function and to the people that come before them. So that is thanks to you for your work, your professionalism, and your dedication, for your contributions. As I note, these innovations show healthy signs of flourishing and expanding in the years ahead, but they're also informed by the need to be flexible and creative in order to continue serving those who are most in need, especially during service interruptions like this pandemic. Given the underlying tenets of specialized courts, built on bringing teams of professionals together to support vulnerable and marginalized accused, I'm not surprised by the collaborative nature of your forum and the many voices that you have heard from over the past 2 days. I'm grateful to all of you for the time and energy that you have invested in reinforcing your connections and reinforcing the future of specialized courts across Ontario. So to conclude, I'd like to extend a special thank you to Kate Almond and Sarah Diaz, who have served as extraordinary co-chairs for this forum. The two of you brought your different skill sets together, Kate as a probation officer and Sarah as executive director of the Kenora branch of the Canadian Mental Health Association, exemplifying the collaborative nature of this forum. And I would say those skills melded together in a way that made for 2 days of very useful, practical information for all of the participants, including me. So thank you very much for everything that you've done in the past 2 days. Stay safe, everybody.
Thank you, Assistant Deputy Minister Kyle, for your thoughtful closing remarks, and a shout out to Sarah and I, sorry, thank you. We appreciate your ministry's ongoing support and commitment to the work of the HSJCC network. We now bring a close to the Provincial HSJCC Specialized Courts Forum. This has been such a great opportunity for us to learn more from each other and think about how we can improve the important work you're going to do going forward. We would like to extend a big thank you to all of the panelists for their time and valuable insights over the past 2 days. We would also like to thank all of our provincial HSJCC partners, and particularly the Ministry of the Attorney General, for your collaboration on this forum and for sponsoring persons with lived experience to attend this forum. A special thank you goes out to Justice Barnes, Dina Bonet, Kandar Patel, and Jocelyn Boissonneau for all of your invaluable assistance in the planning of this forum. Thank you to the HSJCC Secretariat team, Candice, Tasha, Christine, and Andrew for planning and coordinating this event on behalf of the provincial HSJCC. And most importantly, thank you to all of you for taking the time to participate, learn, and share over the last 2 days.
We strongly hope that we have equipped you with more tools and knowledge to improve the service provision of specialized courts across Ontario. The information and key action items put forward over the last 2 days will be turned into a resource that will be available through the HSJCC website. Please stay tuned for that in the near future. The recordings from the sessions will also be made available on the HSJCC website in the coming days. The HSJCC network and its various communication platforms, its website, webinars, social media, and newsletters will continue to be an important knowledge exchange platform for the important issues discussed at the forum. If you're not already involved in the HSJCC network or signed up via our mailing list, we encourage you to do so. I would now like to turn it over to Little Brown Bear to provide us with the final prayer.
Quick, Sego. I just want to thank the Creator and God, or whoever you pray to, as we come to the end of our journey together. We say thank you for providing opportunities along this path for us to witness what has been accomplished over these several days. With the sharing of information, may it provide positive words to help move us forward, to advance and see growth in all areas of organizations and in our lives. And that we must remember that healing journeys are never forced. A healing journey is something that a person wants to be on, and that we think, act, and feel in terms of another person. And as we continue our journeys, that we practice the 3 C's to building a very healthy relationships and practice PTA with one another each day. As we conclude this day, we ask the Creator and thank the Creator for meeting all of our needs and protecting us in all that we do and all that we will do going forward. And I ask the Creator to please bless our eyes as we may see the goodness in ourselves and others, to bless my mouth that I may speak kind words, and my heart that I may give and receive love, and bless my hands that I can feel the love from other people. And that we practice self-care for one another. You know, in life, it's not the tragedy of life that ends so soon. It's that we take so long in starting to live our lives, and that we use the medicines to help us on our journeys. I know in mainstream, they say to practice 8 by 8 by 8, 8 hours work, 8 hours play, and 8 hours sleep. In the Aboriginal world, we practice 6 by 6 by 6 by 6 with the medicine wheel to take care of our physical, our emotional, our psychological, and our spiritual needs. Because if one is out, the other 3 will be out as well. So that we take care of those medicines that help us along our journeys. I just want to thank the spirit animals for coming to help us today from each direction, each of those doorways. And that we all walk with soft moccasins when we help one another. And that someone had mentioned that our language, our words are very powerful. I know where I work in the program that I run, we don't call them clients or patients anymore, but we call them community members because they are part of a community. I know I am part of that community. So I say Niawe, Niawagoa, Miigwech, Tanse, Marci. Thank you for allowing me. It is so honored to walk with you for these past couple of days on your journey. And for that, I say Bamapi Ona Giwahi. Ahau.